Port Howard development. Let me have appearances starting with petitioner's side counsel.
Good morning, Your Honor. It's Ron Van Buskirk for the petitioners in the main. And with me are some colleagues who I would ask to introduce themselves that might argue individual issues per the party's stipulation. It's nice to see you.
Thank you, Your Honor. This is Margaret Rosgay, counsel for petitioners.
Thank you.
Morning, Your Honor. This is Stacey Wright, also with the Pillsbury firm on behalf of the EOSA petitioners.
You're a little, your audio is a little muddy, so you might want to.
Is that better?
Yeah, that is. Thank you.
Yes. I'll speak up. Thank you.
Good morning, Your Honor. This is Eric Mormon, also on behalf of petitioners East Oakland Stadium Alliance.
Good morning, Your Honor. This is Todd Smith on behalf of petitioner Capitol Quarter Joint Powers Authority.
Anybody else from petitioner's side?
Good morning, Your Honor. Eleanor Morton for petitioner International Longshore and Warehouse Union.
Oh, thank you.
And Mike Jacob with co-petitioner Pacific Merchant Shipping Association. Good morning.
All right, respondents and real party.
Good morning, Your Honor. Shay Dively with Myers Nave on behalf of Respondents, City of Oakland.
Good morning, Your Honor. Tim Kremen, also on behalf of Respondents, City of Oakland.
Good morning, Your Honor. Charity Schiller for Real Party and Interest, Port of Oakland.
Good morning, Your Honor. Deputy Port Attorney Kimberly McIntyre on behalf of Real Party and Interest, Port of Oakland.
Good morning, Your Honor. Whit Manley on behalf of Real Party and Interest Athletic Investment Group.
Anybody else need to be appear here? All right. I understand the parties have had some discussions about how to structure the argument. Is that right?
Yes, Your Honor. It's Ron Van Buskirk. We did come to agreement on structuring it. I think we embodied it in our case management conference statement. I believe it has two essential points. One is to request the court's permission to be able at certain times to show a page from the record.
Sure.
And the other was to order the arguments with a brief introduction to one attorney per side, and then to have the argument go issue by issue, at least as to those that are being contested under the tentative, with one attorney per side on the issue, so we don't go party by party. I think I've accurately stated that, and I leave that to opposing counsel.
Yes, Your Honor. This is Shay Dively on behalf of the City of Oakland. I don't know if it's necessary to spend the court's time with any sort of lengthy introduction at all, or and actually we would, considering that the city fully supports nearly the entire tentative, except for one part that we are contesting with respect to when. We really think it probably makes sense for, the petitioners to go through petitioners' objections issue by issue and trade off. So then, exactly as planned. Yes.
Right. And that would be helpful to the court also. Let me just tell you schedule wise. We're going to go till noon. Then if we're not done at that point, we'll take our lunch break and come back in the afternoon. As I indicated before, each side will have at least an hour going forward. If it's necessary to do a bit more than that, I'm prepared to do that, but within reason. We're going to get finished hopefully by mid-afternoon at the latest today. All right. So with that in mind, and I agree, I don't need a big introduction. This is an extensive record. I spent a lot of time, as you can tell, going through it. And I have issued a very detailed tentative ruling. So I would appreciate it if the parties just dive in. Let's go issue by issue. It would be helpful if you identify, as I did in the tentative ruling, perhaps the section of the briefing that you're addressing. I think I actually gave your outline from the petitioner's papers to identify what I was focusing on. So with that in mind, our petitioners ready to proceed.
We are, Your Honor, and while Ms. Dively doesn't want me to give an introduction, I'll just say about 3 or 4 sentences and then turn it over to the issue experts, if I may.
I'll give you 3 or 4 sentences.
Well, thank you, Your Honor. Addressing the tentative, Obviously, we agree with Your Honor with regard to wind impacts and deferral of mitigation there. And, you know, respectfully, we disagree with Your Honor on a number of other items. We're not going to go through the whole briefs and all the issues by any means. We've endeavored to pick out the items we thought were the most important and to be honest, problematic in terms of your ruling. And so our folks are prepared to go through that, and we'll begin in just a moment. But we do, in the end, what we're asking Your Honor on our side is, when we're done, is to please take under consideration our request to take a second look at some of the issues we're raising, because we honestly believe the EIR is deficient in more ways than just the wind impacts. And we think with a project of this magnitude, it really deserves to have the highest quality EIR and a fully deficient EIR. With that, Your Honor, I'll just say we will begin, Mr. Moorman, with and I think they're going to go issue by issue so that we would talk and they would talk, if you like. So Mr. Moorman would begin with air quality and greenhouse gases, then Ms. Rogue on hazardous materials. I believe then that that Todd Smith, Mr. Smith would go next on his issues of the railroads. And finally, Ms. Wright would go last for our side on a couple of issues, alternatives, cumulative impacts, and so forth. And I need to adhere to the sage advice of Judge Wallenstein from the Eastern District to sit down and shut up. And with that, I will pass to Mr. Moorman.
Judge Wallenstein is not presiding over this hearing, so I would probably use somewhat more gentle terms, particularly in the Zoom hearing.
Well, he was referring, Your Honor, to counsel's admonition for cross-examination.
Yes.
The first rule being sit down and shut up, and the second being sit down and shut up. But that's
all right.
Thank you, Your Honor.
Good morning, Your Honor. This is Eric Moorman. I'll be presenting on the air quality and greenhouse gas emissions issues. I'd like to first request, if possible, to share my screen, as there's a few items from the record I'd like to present, if that's okay.
That is fine.
Thank you very much. Okay, please let me know. Do you see the slides?
Not yet.
Oh, okay. Apologies, Your Honor. Can the court see the slides now?
Nope.
Okay. Let's see. Sorry about that.
I've got it.
Apologies. Good morning. As I said, I'll be discussing the air quality and greenhouse gas emissions issues, including the EIR's improper deferral of mitigation of greenhouse gas measures. Specifically, I'll be talking about three issues that we addressed in our opening brief. The first is the EIR's inadequate analysis of emissions from emergency generators. The second is the EIR's inadequate analysis of Howard Terminal displacement impacts, including displacement of truck parking. The third issue I'd like to address is the improper deferral of greenhouse gas mitigation measures. So I'll dive right in. The first issue I'd like to address is the EIR's inadequate analysis of emissions from the project's 17 emergency generators. As the tentative notes, the project would include 17 diesel-powered emergency backup generators, one at the ballpark, and one for each of the mixed-use buildings, for a total of 17. These generators would produce significant particulate and toxic air emissions when they're in operation, i.e. when there's no power. But the EIR unreasonably assumes 0 hours of backup emergency operation from these generators, and therefore assumes that there will be no emissions from these emergency operations. Instead, the EIR assumes only 50 hours per year for maintenance and testing operations. And I'd like to pull up this excerpt from the EIR from the responses to comments, and it makes clear on AR 12019, the calculation of criteria, pollutant, toxic air contaminant, and GHG emissions associated with the use of emergency backup diesel generators is based on 50 hours per year of testing and maintenance, which is the maximum duration allowed by the Air Resources Board Airborne Toxic Control Measure. So that's the assumption the EIR is working with. But this assumption, which is that there be no actual emissions from emergency operation, is facially unreasonable, we submit. It's reasonably foreseeable that some amount of emergency operation from actual emergency operations, which is the purpose of the generators, is foreseeable, since that's the entire purpose of the 17 generators that'll be part of the project. Respondents nowhere provide any support for this assumption that there would be simply 0 hours of emergency operation. There would be only 50 hours of testing and maintenance. They simply assume.
Council, can you slow down a little bit?
Yes, apologies, I will. So in other words, the main point is that respondents just don't account, and the city didn't account, the EIR, for the fact that there will be reasonably foreseeable emergency emissions every year. And it only accounts for the 50 years of testing and maintenance. The tentative cites to AR 961, which I'm going to flip to here, which is this table called Total Unmitigated Average Daily and Annual Operational Emissions by Source. The tentative cites to this, but if you look at the footnote at the bottom, which I've somewhat excerpted here so as not to include the entire table, it does say that the emergency generator assumptions are based on emissions from the testing and maintenance of diesel-powered emergency generators. So again, that just reinforces the point that this table does not account, and the EIR does not account for actual operational emissions from these generators, which can be significant. This assumption of 0 hours of emergency operation caused the EIR to significantly underestimate emissions and health risks from the generators. So this is not, in other words, this is not just a small technical issue. It actually prevented the public from fully understanding the entire scope of the potential emissions from these potentially significant operations. The tentative also cites to AR 12018 from the city's responses to comments, which states that the EIR's analysis is based upon, quote, reasonably foreseeable future hours of operation, not the hypothetical maximum hours of operation used for permit regulatory purposes that is used, or PTE. Again, that's AR 12018. So this refers to the Bay Area Air Quality Management District policy that the petitioners referenced in our opening papers. And that basically provides that 100 hours per year of generator operations without outside power is a reasonable worst case assumption. In other words, it's a reasonable scenario that the EIR should have considered. Petitioners believe that this guidance should be entitled to deference, and we believe it sets a reasonable amount of foreseeable hours of operation for these generators. But even if we set this guidance aside, and even assuming it doesn't apply to the CEQA analysis, the EIR simply fails to explain why its assumption of 0 hours of emergency operation is reasonable. The EIR also notes that the project is not in a higher fire risk area and is not included in the state's fire threat map. And therefore, public safety power shutoffs, or PSPSs as they're called, are not reasonably foreseeable. And this issue, I think, was also addressed in the tentative. But power shutoffs can occur for a variety of reasons other than fires. For example, the project's in a seismic zone, active seismic zone. An earthquake could potentially knock out power. There are all kinds of scenarios besides fires that could cause significant power disruption to the facility, to the project. But the EIR doesn't address any of that. It just assumes, without any supporting information, that there will be no actual emergency operations, only operations for maintenance and testing. And we submit respectfully that this assumption is unreasonable and should not be entitled to the court's deference. Finally, as the last issue on this, I just want to underscore that this error is not just a minor technical issue. It causes the EIR to significantly understate or underestimate the significant human health and environmental impacts from the diesel generators that'll be part of the project. And we believe this was an abuse of discretion. I just want to conclude very briefly on this issue by addressing the standard of review. It looks like the tentative assumes that this is a substantial evidence issue, but we respectfully would submit that this is an issue where the EIR simply did not address, or it omitted significant impacts, and therefore we respectfully think this should be addressed under the de novo standard of review. So with that, I'll move on to the next issue I have, which is displacement of impacts, or displacement impacts from moving existing operations from Howard Terminal to other locations. So this issue we realized was addressed extensively in the briefing. So I'll just highlight a few key points that we'd like to address. The first is that these relocation impacts are extremely significant. I'll show another slide here.
Give me 1 second to find out.
Yes, Your Honor.
Part of the brief, where in the TR you're actually referring. So I think that's a different portion.
Yes, Your Honor. It's a different section of the brief.
It's in the beginning, section C.
That's correct. Yes.
Okay, I want to make sure I'm on the same pages as you are. All right.
Correct. Apologies for that. So yes, this is section 4C of the opening brief, Howard Terminal displacement impacts. So this issue was addressed extensively in the briefing. So I'll just go through fairly quickly and highlight the key points. The first is just to underscore the fact that these relocation impacts are potentially very significant. The EIR acknowledges the project would displace all current heavy industrial activities at Howard Terminal, more than 50 acres worth, including truck parking and layover, container storage and drayage operations, office uses, and others. And these are shown here in the responses to comments slide, which shows the updated acreage for each of the current uses. So these activities are going to need to move somewhere, but the EIR makes a critical error in that it fails to fully analyze where these uses will actually go, where they'll move to when they're displaced by the project, and the reasonably foreseeable environmental impacts from this relocation, including significant impacts to transportation, greenhouse gas emissions, air quality, and others. They simply claim that these impacts are too speculative to study, and they move on in their analysis. Respectfully, we think this falls far short of the level of disclosure that CEQA requires, and it leaves the public without a full picture of the significant impacts from this relocation. In particular, the EIR's displacement analysis relies on two flawed assumptions. The first of these is that the city claims it has no idea where existing uses are going to relocate once the project displaces them. But the city actually identifies, as we note in our papers, two potential relocation sites near Howard Terminal. The first is the Roundhouse property just west of the project site, and the other is the Oakland Army, the former Oakland Army base, or the OAB for short. The EIR incorrectly assumes that these locations will have enough capacity to accommodate the activities displaced from Howard Terminal by the project, including truck parking, but not limited to truck parking. But the city ignored evidence presented by petitioners and the public agencies, several public agencies, that the Roundhouse and other areas in the seaport do not, in fact, have enough capacity to accommodate these displaced uses. For example, the Bay Area Air Quality Management District noted in its comment letter that the Roundhouse facility is already at capacity and there are no known plans to develop new or additional parking facilities. And that's at AR 11675, the BAA QMD comment letter. So this was an issue that, in addition to petitioners, numerous agencies identified this as a significant problem with the EIR's analysis. But the city ignored this evidence that was presented by petitioners and the public that the Roundhouse simply doesn't have capacity. Both the tentative and the respondents point to the 2050 or the 2019 to 2050 cargo forecast prepared by BCDC as evidence that the seaport can absorb displaced Howard Terminal operations. But that forecast is just a projection of future parking needs. In other words, it doesn't tell us anything about the current parking capacity at the port or whether the port can, in fact, absorb displaced uses from Howard Terminal.
Well, even, you may get to this, but assuming that you're correct, that there is no more room at these locations, the city's response to that is, well, you know, this is a worst case analysis. If there is no space there, we got to go to the next place, which is we can't predict where to go, where parking would go for the reasons. But they use the worst case analysis to assess potential impacts about local displacement.
That's correct, Your Honor, and I will address that. But I will say for now that it's correct that the city uses the Roundhouse facility, which is immediately next to the project area, as a worst case analysis for essentially the local analysis of emissions from toxic air contaminants. And so that part of the analysis we don't contest. We think that's fine. The issue, though, and that I will describe in some detail, is the VMT analysis. So there's two parts. The city uses sort of what it calls a two-scale analysis. And the first part of this, the first scale is essentially what Your Honor mentioned, which is the local impacts from TAC emissions. But But then there's another part of the analysis where the EIR essentially addresses VMT in the regional analysis.
Look. Hello, whoever that is, please. Thank you. I think they're muted. I'm sorry. You said
Not a problem.
you contest the regional analysis, what you were saying.
The regional analysis, correct. That's the analysis in which the city looks at the VMT, or vehicle miles traveled, which feeds directly into the greenhouse gas and air quality analysis. And the problem with that part of the analysis, which I could describe a bit more with some citations to the record later, is that it just didn't account for the possibility that the VMT could increase. The city simply says, there's a possibility the VMT might increase and the associated greenhouse gas emissions and air quality impacts and transportation impacts might increase as a result. But we simply can't study that because we don't know where the existing Howard terminal uses are actually going to go. And we submit that this is really not the good faith effort at full disclosure that CEQA requires. The city was required to undertake some investigation before concluding that this issue was simply too speculative to study. And we submit that the city did not do that. To take one good example, the city refused to conduct surveys of existing tenants to simply ask them where they might go, as petitioners and other commenters suggested that they might do. The city responded that the surveys of existing tenants and drivers couldn't be utilized, and I'm quoting here from AR 11342, responses to comments, the consolidated response. They say that the surveys couldn't be utilized because the information would not be reliable or static, and that tenants and drivers simply change over time. And any responses to the survey would not be binding or capable of confirmation. We could change before the start of the project construction/lease termination if the project is approved. And this is just one example, and the city simply stops there. It looks at essentially the roundhouse, as Your Honor mentioned, as a sort of a test for a worst case scenario for TAC emissions, because that's close to the project site. But then it simply doesn't look at the VMT analysis, which brings me here to the second main issue that we have.
Before you go there, could you give me the AR site again for that comment about surveying?
Oh, certainly. That is AR 11342, and this is from the city's consolidated response on truck parking,
Okay.
which is, we believe it's really the only place that the city addresses this issue in detail. So that all brings me to the second key point, which I alluded to earlier, which is the EIR's inadequate analysis of VMT, or vehicle miles traveled, from displaced Howard terminal uses and associated emissions, and from GHG and also transportation impacts. The EIR acknowledges that VMT associated with truck travel is quote unquote likely to change due to the project. And to read the full quote, that's at AR 930. The air quality section, which says VMT associated with truck travel is likely to change, but the magnitude of the change and whether VMT will increase or decrease is currently not known by either the project sponsor, the city, or the port. Therefore, estimating the change in VMT and resulting emissions increases or decreases would be speculative and therefore is not conducted. So again, and also I should say the city notes that the length of truck trips that currently use Howard Terminal could increase if truck parking relocates outside the seaport. And that the citation for that statement is AR 11344, which is again, the consolidated response. So you can see that the city acknowledges that VMT is likely to change. And it even acknowledges that the length of the truck trips could increase. And therefore, emissions impacts, emissions from GHGs and other air quality emissions, as well as transportation impacts, could increase as a result of this project and the displacement. But the EIR fails to analyze the foreseeable impacts of that change, again, simply labeling it too speculative to study. And the city points to this two-scale analysis I sort of alluded to earlier, in which it looks at local and regional emissions, but this does not remedy the error. As the tentative notes, the EIR uses relocation of trucks to the roundhouse as a worst-case scenario for the local analysis of TAC emissions for purposes of analyzing health risk. And so to sort of wrap this section up, this analysis simply does not account for the reasonably foreseeable increases in VMT from trucks being displaced from Howard Terminal, being displaced further from the port, and having to travel longer distances and associated air quality and transportation impacts. To conclude on this issue, because of these errors, the EIR we submit does not provide the public with a complete picture of the potential GHG and transportation impacts of displacing existing activities, and we submit that this is prejudicial error. So unless there are questions about that issue, I'd quickly move on to the last issue I'd like to discuss in air quality, which is the improper deferral of greenhouse gas mitigation measures. So this issue was discussed extensively in briefings, so I'll just highlight a few points here. The court knows our position. The EIR's single GHG mitigation measure, GHG1, improperly defers mitigation of the project's GHG impacts to a future GHG reduction plan without committing to specific performance standards as CEQA requires. The no net increase standard we submit is not a specific performance standard under CEQA. As discussed, as Mr. Van Buskirk alluded to earlier, the CEQA guidelines allow for the specific details of the mitigation measure to be developed after project approval in certain cases, including when the city or the agency adopts specific performance standards that the mitigation will achieve. Here, we respectfully submit that the EIR does not articulate specific performance criteria that would ensure inadequate mitigation. We believe GHG1 suffers from the same problems as the measures rejected in the POET and CBE cases that we cited in our briefs. We discussed those cases in quite a bit of detail in the briefs. I'll leave that to the briefs unless Your Honor has any specific questions about those cases. But we believe that, like those measures in those cases, GHG1 sets out a general performance standard, i.e. no net additional increase in GHG emissions, and defers mitigation to a future GHG reduction plan to be approved by the city after the CEQA process has concluded with no further public input or review. And you can see here the text, of GHG1, which provides in part the GHG reduction plans shall specify anticipated reduction measures sufficient to meet this no net additional GHG standard. Now we submit this is not a specific performance standard. It only sets a generalized goal of no increase in GHG emissions. And the measure really provides no assurance that the mitigation will actually occur. And we think this is very similar to the measures that were discussed and rejected ultimately in the CBE and POET cases. Those courts found that no net increase does not set an adequate performance standard sufficient to allow deferral of mitigation under CEQA.
Well, this is going to come down to whether who is reading those cases correctly or not. I think I laid out in the tentative ruling why I think that the record here is substantially different than in both of those cases. I could be right or I could be wrong. I think that's for another court to decide. I pointed out some distinctions, not the least of which is some of the menu of additional measures, the type of analysis that's required, and the stage of the analysis, which I think are different than what's in both CBE and POET. Again, those seem to the court to be a distinction. And somebody else may have to tell me I'm right or wrong.
Right. Yes, Your Honor. So I understand from the tentative that the court found, Your Honor found that those cases are distinguishable in facts. But I think we would respectfully submit that when you look at the statements that the courts made in CBE and POET, that these are essentially very similar types of mitigation measures. We understand the circumstances are somewhat different. Here, the EIR provides, analysis, whereas in CBE, the issue there was that the EIR simply brought up the GHG issue at the very last minute, and it kind of hastily cobbled together some mitigation measures. So we understand that some of the issues are a little bit different, but we would submit that the no net increase standard is the same in this case. Which is to say courts, including CBE and POET, have found that that no net increase standard does not qualify as a specific performance standard that's sufficient to allow deferral of GHG. And I would just quickly note that very similar to the CBE case, in this case, as Your Honor mentioned, the tentative, the city does list some required mitigation measures for reducing GHGs, but it also lists a menu of possible measures. But these measures are extremely vague, and the city relies on both the required measures and this sort of menu of potential measures. So that relies on a combination of those things. And we would submit that simply doesn't assure the public that these measures will be reduced. And it simply uses this no net increase. Generally, it's really just a goal rather than a specific performance standard. And so that's respectfully what we would argue as to why this case is very similar to the case, particularly the case in CBE, where the city deferred the formulation of mitigation measures for GHG emissions till long after the project approval. And we would argue the same issue is true here. The city simply punted the issue. It lists a few required measures, but the majority of the measures, when you flip through the mitigation measure, which is 14 pages long, the menu of measures, most of these are extremely vague. I'll just give a few examples. One of them is minimize the project's energy demand through physical design features, or quote, reduce refrigerant emissions, or increase use of reusable bags. So we would submit that, the city relies on this menu of possible measures, but we think that this simply doesn't provide any sort of assurance to the public or public agencies that the city is actually going to reduce GHG emissions to this net zero standard that the city claims from AB 734. So I think, Your Honor, I'll leave it with that unless you have any further questions. But I think I'll now hand it over, unless you have further questions, to the hazardous materials analysis.
Well, I thought we were going to go issue by issue. Wouldn't it be appropriate to have the response at this point to what you've raised?
Certainly, Your Honor.
Who is responding on these issues?
Good morning, Your Honor. Tim Kremen on behalf of the City of Oakland. I will respond on the issues of the emergency generator and greenhouse gas. And we'll ask Shay Dively to respond on the Howard terminal displacement impacts, because those are kind of a mix of issues between air quality assumptions for displacement. Can I ask Eric to stop sharing his screen just because it creates...
Yes, thanks. Apologies.
Thank you. Okay. So, Your Honor, I'll address emergency generators first. And I think although they did it at the end, the real place to start is the standard of review, because that's critical here. And as they've done in a number of instances, they've tried to say that the standard of review is de novo because, quote, no study was done, and they point to the Sierra Club case. Well, that's clearly not what their argument is. Their argument is that they disagree with the methodology and the design of the study, because it was studied. Emissions from emergency generators were included in the air quality analysis, and they're saying they didn't include enough of them, or they disagree with the assumption of the types of emissions included. So if you reference our opposition brief on page 18, where we talk about standard of review, where the attack is on the methodologies and studies used for the impacts, then it is a substantial evidence test. And I think that's critical to start there. And so that's what I have to say about the standard of review. Then moving to their claims about the reasonableness of assumptions. Again, even when they say that, that shows that it's a question about methodology or type of information included in the analysis. First, their objections were responded to in detail in the responses to comments, which the court notes in its tentative ruling, and that's at AR 12017 through 12019. And I want to just briefly summarize it, because the basis for the assumption of including 50 hours of 50 hours of testing, as they called it, as the basis for the methodology, there is a reasonable basis for that assumption. And I will point to what they pointed to in the original comment, which is, well, what about what BACMID requires, which is the expert agency that addresses how air quality analysis should be done in our district, which includes Oakland. And at first they pointed to, well, BACMID requires 50 hours of operation for its permit to emit. That's a horse of a different color. And that's explained in the response to comments, in that the permit to emit is talking about overall emissions during operations. And in a CEQA context, you got to go year by year. So it's an apples and oranges comparison to saying that BACMID requires us to include 100 hours of operation because that's what they include in the permit, because that's not an annualized number. And also that is like a total number that the generator can emit. Now, more importantly, BACMID has on point its CEQA guidance. And we're talking about a CEQA document here and an EIR. And according to BACMID's CEQA guidance, they don't say that an annualized operations emissions should be included. That is the expert agency's opinion. It's entitled to deference. It's what the city relies on here. And in fact, BACMID, which submitted a rather extensive comment letter on the draft EIR, never mentioned this issue. The city consulted with BACMID. They never mentioned this issue. And their guidelines say what they say. And again, this is in the response to comments, Your Honor. So I don't want to.
Is this that, I want to make sure I'm looking at the right place, though.
Okay.
In that case, is the comment response on 12019? Is that where you're looking?
Yes, it's on 12018 through 12019, where it talks about BACMID's guidance and what it requires. So when you talk about the basis for the assumption, I point to the expert agency. And, going back to standard review, it's not the petitioner's or the court's role to design or determine the methodology for analyzing impacts. One last thing I want to say that is actually critical, because they make an unsubstantiated assertion that, well, this is a problem because at the end of the day, you grossly underestimated the health risks from the emergency generators. That's an unsubstantiated assertion that they're making. And in fact, there's information in the record that shows that the health risk from emergency generators is very low. And I'm sorry, I'm going to turn to the page to find it. It's 1.7. And let me give you the site to where it discusses the mitigated health risk for emergency generators. The point is that the threshold is 10. Okay, that's 10 in a million. And they're making this assertion that we don't include an annualized operation level results in a, way underestimate of that. So on page 89292 of the administrative record, it says that with the implementation of the mitigation measure, which regulates the emissions from emergency generators, the maximum cancer risk is 1.5 when the threshold is 10. So that means there would have to be over a 7-fold increase in the health risk due to some type of annualized operation of emergency generators. It's just not going to get there. So they've made a statement that has no support in the record. There's contrary evidence in the record. So concluding by, at the end of the day, we think we're right by not including an operations number. Realize the 50 hours that we did include, that we call testing, is highly conservative. That's discussed in the response to comment also. It's likely to be much less. So we have a 50 number in the analysis. It probably is an overestimate of testing. And for all the reasons I stated, I think the methodology is supported by evidence. It's entitled to deference. At the end of the day, that this inclusion of some number, which they don't say what it is, and they point to nothing that says what the number should be, except for the PP by BACMID, which we said is not applicable. The impact is not understated. Any questions, Your Honor?
No, just keep going. I'll interrupt if that's something.
Okay, thank you. So just to keep it from bouncing too much, can I move to greenhouse gas?
Yes.
And then turn over to Ms. Steinle? I will say, Your Honor, the 10-year ruling is extensive, and I will say, completely right, and marches through every issue that Mr. Moorman raised at this hearing. Yeah, I don't want to read it back because you wrote it, and I don't want to read back what we wrote in the opening brief. But the reliance on CBE and POET is, again, it's apples and oranges completely. There's a couple of quotes from the CBE case and POET case that I'll just read you the CBE quote that shows that it's completely different. So this is on page 95 of the CBE case. Quote, the lead agency in our case delayed making a significance finding until late in the CEQA process, divulged little or no information about how it quantified the project's greenhouse gas emissions, offered no assurance that the plan for how the project's greenhouse gas emissions would be mitigated to the net zero standard was both feasible and efficacious, and created no objective criteria for measuring success. I mean, just reading your tentative, that's clearly not what the city did in this case. Similarly, in POET, the court said it's a bare bones mitigation measure where the lead agency failed to analyze the amount of emissions or commit itself to a specific performance standard. As part of the mitigation, they said they'd conduct an extensive testing program to determine the extent of the emissions. Like, they didn't even have the number of what the emissions were in that case. And we'll follow that effort after they figure out how much the emissions are with rulemaking to establish specifications to ensure there's no net increase. Again, like, that's POET at 739. I mean, relying on your tentative, there's no way this mitigation measure does that. And the last thing I'll say is they still stand by this argument that the no net additional performance standard is not, like, per se allowed under CEQA. That is not only not supported by law, but makes no sense in a statute, the purpose of which is to reduce environmental impacts. Why it's not supported by law is nothing in CBA supports a proposition, and they cite nothing. So you can turn to POET, and POET has some language at the end of a long paragraph that, one sentence taken out of context that they're relying on to say that no net new is per se improper under CEQA. But POET merely said that you can't adopt a performance standard without demonstrating with substantial evidence that it can be met with specific criteria and methods. And that's POET at 740. Lastly, just on the mitigation measures, which I think the court does a great job of marching through, I will say that also the EIR demonstrates the effectiveness of each measure in reducing impacts. It actually quantifies the amount of reduction from the measures. Those are in technical reports that are attached as appendices to the EIR. There's a bunch of them. I'll quickly but slowly read the AR sites, which is 3092 through 3094, 3208 through 3217, 88215 through 216, 88234 through 235, and 88243 through 244. And the reason why that's critical is there's actually a quantification in those technical reports of the emission reductions from each of the measures. And that's also was explained in the final EIR responses to comments to these objections that were raised. And lastly, Your Honor, although we objected to the amicus brief, I will say that in our response to the amicus brief, there's also a detailed discussion of the claims made in that brief about greenhouse gas. And so I'd also point the court to our response to that issue in our amicus response. And with that, any other questions, or else I'll turn it over to Ms. Darwin.
Let's turn it over to Ms. Darwin.
Thank you, Your Honor. I'm just going to talk very briefly on the displacement issue for the tenants at Howard Terminal. similar to as Mr. Kremen said, we actually, the tentative ruling went through these issues in quite detail. Actually, Mr. Mormon didn't raise any new arguments that weren't already in the briefs that have been extensively kind of addressed by the court's tentative and in the briefing. Just to touch on three main points, if it's of any help, starting off on the challenge to the roundhouse. I think this is it's apparent this was a red herring argument, because in the end, petitioner's counsel concedes that they're not contesting the roundhouse as used as the worst case scenario. So I think that this is mostly argument without any purpose. Regarding the contention that the EIR improperly discounts the use of surveys of the existing tenants to try to provide more information as to possible future locations. This was mentioned just in a footnote in petitioner's opening brief, but our brief does actually respond in detail and does point out the response to comments on this issue at AR 11342. What the petitioner's counsel said that our response was cursory, but actually if you look at it, it's nothing like that. It explains that how surveys are not reliable in this sense, because they're not binding. They can change over time. They're that this is a dynamic industry and things are already changing or constantly changing. And actually what I thought would be really helpful to kind of hone in on that point was exactly the slide that Mr. Mormon pointed out, that at AR 11339, which showed that the changes in the uses at Howard Terminal actually changed during the process of the EIR. And we had to update the various uses and change the acreage in our final. And that's because these tenants and these users and subtenants and people who use the tenants' parking spot are constantly changing. So the idea that of using a survey to try to pinpoint where these folks would go, it was justifiable that the EIR explained the factual rationale for why the surveys would not, in the city's sound discretion, actually provide useful and reliable information. Finally, I did just want to briefly touch on the point of the VMT. Again, I want to point out that the EIR does keep the emissions from existing activities at Howard Terminal, the actual VMT emissions, in the regional calculation. Because it assumes that all the trucks that are right there, the current users of Howard Terminal, will remain in the air basin and will be still utilizing going to the port. And so everything in the entire air quality analysis assumes these existing uses will remain, and we include that in our analysis of the air quality impacts. And that is actually explained at AR 928 through 929. It's also explained in response to comments at 11348 at 11349. What I want to mention is that what we could not do is we could not identify where these trucks might go. And we disclosed that in the EIR. So it is absolutely true. The EIR acknowledges that truck travel is likely to increase because the relocation of trucks. But the EIR concludes that these changes cannot be quantified or studied because the exact locations have not been identified. This is disclosed in the EIR, and it's not a deficiency. It's an explanation of why that information is too speculative to know. However, again, we didn't subtract out existing uses. It's kept in, and there's nothing wrong with disclosing that this information is not available and analyzing as much as we possibly can. And so these challenges to the displacement impacts just are without merit, and the analysis in the EIR is fully supported by substantial evidence in the record. And if the court doesn't have any questions about that, I can pass it back over to petitioners.
I'll go with petitioners. And in terms of this analysis, I'm giving each side a response I will allow a very brief rebuttal as we go each place, but the record's pretty fully exhausted. So if we have something new, Mr. Mormon, you may raise it.
No, thank you, Your Honor. I think given the number of issues that petitioners have to address, I think I will go ahead and reserve the rebuttal for now and pass it over to the next subject area, if I may.
I appreciate that. Thank you. All right, what's next?
Well, Your Honor, it's Ms. Van Buskirk. So I think next is Ms. Wright, who is going to address a number of issues so that we can speed up, keep this thing going as quickly as possible.
Fair enough.
Thank you.
Okay, thank you, Your Honor. If you agree, the sections I would be addressing are 5, 6, and 7 of your tentative ruling, so we would be jumping ahead.
So when you say 5, 6, or 7, I don't know if I count them quite that way. It's under section. Are you talking about alternate? What's the narrative issue?
Yeah, so the first one would be the tentative ruling, which I have as number 5, which would be the improperly deferred mitigation for wind impacts.
Wind impacts, okay.
On that issue, we aren't contesting the tentative. We think Your Honor got it exactly right. So I can address it or just wait for a rebuttal, whatever your preference is.
I think on that one, the ball is in the respondent's court. You should quit while you're ahead and wait till they say something.
Sit down and shut up.
There you go.
Okay. All right. So then what I would jump to is I have it as number 6 in the tentative ruling. This is the land use impact.
Okay, let me get to it.
And if I can tell, I'm going to be
land use conflicts. That's what you're looking for.
Exactly.
Okay.
And specifically, it's page 31 of the PDF. If that's helpful of the tentative ruling.
I don't have those page numbers, but I've got land use conflicts item number 6 in front of me.
Okay, here we go, Your Honor. So I really just have one point to make. I'm not going to repeat everything we said in our brief. But just to set the table a little bit, as we all know, this project is located in a very busy seaport. 99% of containerized goods moving through Northern California are loaded and unloaded through the port of Oakland, and the seaport functioning is extremely important to the state. And so what we know the EIR found that impacts to land use impacts would be significant. The question is whether they're mitigated effectively or not. I just want to I'm going to try to speed this up and cut through this a little bit. I want to turn to mitigation measure LUP-1B.
Let me say that again, LUT what?
It's LUP-1B. This is the mitigation measure for maritime conflict.
Oh, I got it, yes.
Okay, excellent. And I know Your Honor has already looked at this in detail. So I wanted to address the conclusion in the tentative ruling approving this mitigation measure because, and I'm quoting, it requires the city, port, and Oakland A's to regularly meet and review the effectiveness of the measure and to revise as necessary. And Your Honor, respectfully, I submit that there are 2 problems with that conclusion that I hope you will reconsider. The first is, and bear with me here, if we could do another screen share, we have a slide so that everyone can see the language I'm reading. Eric, if you wouldn't mind pulling that up, I would appreciate it. Thank you. So if you would look at, this is the mitigation measure under timing of implementation and timing of, and method of monitoring. What you'll find is that the implementation of this protocol to reduce impacts to vessel transport and other maritime conflicts only requires monthly reviews during baseball seasons in which games are played at the ballpark, and also requiring at most monthly meetings during baseball seasons. And so what I would submit to Your Honor on that first point is that the EIR makes it clear that in terms of the large events that could occur on the project site, up to approximately 354 games, concerts, and other events occurring not just at the ballpark itself or that venue, but also at the waterfront park. So that's nearly every day.
Can I stop you for a second? I'm lost which mitigation measure you're actually looking at. Is this 1A or 1B? And actually, I can't tell because you're on the page after the heading.
Oh, did I might have misspoken. I believe it's 1A. I'm sorry, I have a little, yes, it's 1A.
1A, okay, that's where I got lost. I was looking at 1B.
Gotcha.
So you're looking at the boating and recreational water safety protocol?
Correct.
Okay, and there your argument is it's plan to plan, not anything concrete. That's your argument?
That's one of our arguments. However,
Okay.
right now, and excuse me, Your Honor, I think that point is addressed in our brief. So
Yes.
what I'm just raising right now is the scope of this protocol and when it's going to apply and how it would be revised. And so if you look, on the screen, you can see timing of implementation under the third column and timing and method of monitoring. The issue I'm having is that I think a lot of the analysis focuses on this project as a baseball stadium. It's not just a baseball stadium. This is going to be a huge venue and draw that will be bringing tens of thousands of people to the waterfront, which is the city's goal. The issue here is the conflicts, the land use conflicts significant that are going to result in this case to water safety, to vessel and other maritime uses in this extremely busy port that's used regularly. The issue I'm having is that this mitigation measure only requires meetings to review and look at the plan only during the baseball season, whatever that means, it's not specified, but not during the other times of the year where concerts, other events could also be occurring, or these impacts also will be occurring. There might be, if there's an admission that monthly meetings might be required during the baseball season to adjust the plan as necessary, why would that not extend to every month of the year? The second point is that in terms of revisions to the protocol, because the tentative ruling noted that the protocol can be revised as necessary. It can, but at the discretion of the city. However, the port is only allowed, and this is a quote again, to require a quote additional operational safety measures, end quote, that are similar to the initial protocol, meaning all they could do is add signs or something else to the effect that is already a measure that's already in the protocol, essentially. And so with that, Your Honor, I just wanted to note again that these conflicts, the EIR notes this, can result in significant delays to vessel transit, truck transportation, and could require several days or more to return the port to normal operations. And this is at AR 1475 to 1476. So imagine that scenario with back-to-back events. There could be a baseball game one day, there could be a concert the next day. Days and days of disruption to port functioning. So, and with that, Your Honor, I would submit the rest of our issues on our papers.
All right, let's have a response from respondent. Let me first start with the last issue, and then we can go to wind impact after that.
Okay.
Respectfully, Your Honor, this is Shay Dively. I can speak about land use impacts. I actually think it probably makes more sense to discuss wind after petitioners go through all their objection. So that's the only thing we're objecting to. As long as I definitely want to get to wind. I'm not saying I don't.
Okay,
But.
we can put wind aside for now since we didn't have anything added for right now at my suggestion. So let's talk about the issue about OUP 1A. And let me just start by saying, is it correct that the mitigation there is limited solely during the baseball season?
Respectfully, Your Honor, no. The mitigation applies to large events at the stadium and baseball. I will also have to object on the record that is a completely new claim. We have never heard that allegation before. It wasn't in their brief, and it's I don't believe they even exhausted it below this concept that it doesn't apply the rest of the year. But the mitigation expressly, LUP 1A, applies to large events, not just baseball games. And actually, that was what the petitioners challenged, was the claim that, oh, but what about the smaller events and everything else? Again, as the court pointed out in its tentative ruling, the whole point of this possibility of a maritime conflict is it's based upon the issues at McCullough. And so we really were looking at the way the project is actually positioned and everything. We're not expecting the same issues, but we still so respectfully, Petitioners Council is really overstating what the EIR found. It concluded that there was a potential for significant impact in this respect, and imposed this mitigation measure. But since the project itself doesn't include any facilities for watercraft or any direct water access, and those facilities are already part of existing setting, what we did look at was the potential indirect impact evaluated in the EIR due to large events, and that applies to anything, not just baseball games. And that is actually in the text of the mitigation measure itself. I think it seems to be that they're challenging something like maybe how something is written in the MMRP. Again, completely new challenge. But anything, what the description of the mitigation measure in the EIR fully covers large events. I'm honestly, Your Honor, kind of confused about what to address here, because the tentative really addresses this issue in quite detail other than this new one. Is there something more that the court would like me to?
No, the hearing today is to address argument.
Okay.
I read the briefs, and I'm leaving it to folks to tell me if there's something they think I got wrong or something they want me to analyze. If they raise it, then I'll hear a response.
Okay, Your Honor. I think we covered it all, unless there is some additional concern about what was discussed there.
No, let me ask petitioner to respond to the suggestion that this is a new claim, that you did not brief the issue of the scope being beyond baseball. I do recall that the argument in the brief had to do with the distinction between large events and small things. And that was litigated in the papers, and I did address that. But where did you raise this argument in your brief about the question of only the baseball events are covered?
Yeah, fair enough. And it's a fair enough point. I don't know that we actually raised that argument as such. And so I can't cite you a page, but I think our argument is basically that the mitigation measure would not be effective to cover all impacts. And so what I was just focusing on now, because the MMRP controls over the EIR, and that was adopted for the CEQA findings, is just that the schedule of the meetings, we're not saying that the mitigation measure doesn't apply to all large events, it does. But in looking at the implementation of the mitigation measure, meetings, so to look at the protocol and see how it's going, make revisions, would only occur during the baseball season. And we thought that was an oversight for
Did anybody raise this below, though, during the administrative process? It sounds like this is a new issue, which is outside the scope of my review.
go ahead.
Your Honor, I also wanted to point out that actually she raised two new issues, because she also said she contested the issue of what the court could raise in these meetings, and that was never mentioned either. And so I did want to put that objection on the record as well. So I believe these are both two brand new issues, never once raised in the whole process.
Yeah, I don't think that's correct. And that was part of our comment letter. We did talk about the protocol and sort of the tied hands of the agencies in revising it. That was part of our comment letter.
But this question, though, about during the baseball season, you can't cite me anything in the record or in your opposition brief, in your opening brief, that raises this issue.
Unfortunately, as I sit here right now, I can't quote you anything. I do think it falls within the scope of our comments, and I would be happy to provide to the court later an AR site.
Well, I certainly didn't see anything in your brief.
Understood.
All right.
Okay.
All right. I was ready to move on to the next issue. Is there anything further you want to tell me?
Nothing for me.
All right. What's next?
Okay, so next, so this is what I have is number 7. This is the cumulative impact, the analysis of the turning basin project or lack of.
Hold on 1 second. Let me just get there. Cumulative impacts. Okay. Go ahead.
Okay, thank you, Your Honor. Okay, so I hope I'm going to give you something to reconsider on this point. I think this is a unique circumstance for this case. The question being whether the turning basin widening project on the corner of the project site was a, quote, reasonably foreseeable, probable future project, end quote, that should have been included in the cumulative impact analysis. The tentative ruling cites Gray v. County of Madera for the rule that courts have found that projects undergoing an environmental review are reasonably probable future projects. And you know, as the court is aware, the issue here is that petitioners and several other commenters requested that the city conduct a cumulative impact analysis that would incorporate the turning basin widening project. One, because it would occur in the same location as the ballpark project, and also because there had already been a commitment to the project in the sense that the port and the Army Corps of Engineers had already expended some money, entered into an agreement for the first step in the regulatory process, which was the environmental assessment and feasibility analysis. And so
that raises an interesting legal point, which is under the case law, is the mere fact that somebody is doing a feasibility analysis, does that transform it into reasonably probable that it's going to be a project? I'm just noting the timing of all this, that the ultimate notice for the this particular project didn't actually go out until quite a long time after the draft or the final EIR. In fact, I think it's not till May 31st, 2022. That's when they actually made a commitment. At what point prior to that does it reach an area of ripeness that the court should conclude that it's reasonably probable?
Sure, and that's fair enough. That is the question.
Right, that's the nub of it, and that's what I have to struggle with.
Understood. And so I think if you look at the cases, there is authority that, and even in Gray v. County of Madera, that there is no hard and fast rule that the cumulative projects are always determined, one, at the time that the NOP, in this case for the ballpark project, is issued, or two, that they should be included only if an EIR process is begun. I think there are kind of two questions there. First, in terms of when the city was required to make this determination of, you know, at what point in time are they looking at the status of the project and when it should be included, they cut it off at the time of the NOP. You know, for some cases and some projects that might make sense. For here, it doesn't. And why is that? The rule that the city has cited comes from the SOMCAN case. And they're citing this CEQA guideline that we're all familiar with, section 15125A1, which generally concerns the environmental setting at the time of the NOP. However, that guideline states that the setting should be accurate and should change where necessary to provide the most accurate picture practically possible of the project's impact. And so here I would say the issue was that the port was proceeding with this feasibility analysis. There was no indication that this project wouldn't go forward. As part of the ballpark project itself, they assumed and recognized that this project was reasonably foreseeable enough that they analyzed the maritime reservation scenario, meaning that if the turning basin project went forward, the project would need to shift to a smaller footprint. So here, I think that it was a reasonably foreseeable, probable future project and should have been incorporated into the EIR analysis. Why? Because the default is more disclosure of impacts, not less. Ms. Stigley also noted that updates were made based on changed circumstances of uses at Howard Terminal as the EIR process went along, and as it should. But they didn't do that for the status of the Turning Basin project. The port here is a real party. This is their project. They knew the status, but it wasn't incorporated into any of the EIR documents. Second, I think the rule is not that an EIR has to be started, and so I don't think that we need to necessarily use the date of the NOP for the Turning Basin project EIR as the date that it is probable. I think that occurred earlier in time, and why is that? Because cases hold that where a significant investment of time, money, and planning has probably occurred, the project is probable, rather than merely possible. This is cited in our briefs. This is the Golden Door case and the San Franciscans for reasonable growth versus City and County of San Francisco. Also in the Gray v. County of Madera case that Your Honor cited, I'll quote from that case also at page 1127 to 1128. Quote, any future project where the applicant has devoted significant time and financial resources to prepare for any regulatory review should be considered a probable future project for the purposes of cumulative impacts. And so I would say any regulatory review would absolutely cover the environmental assessment and feasibility analysis study that was underway. And the fact that the port, as part of the term sheet, had reserved a portion of the project site for this project to go forward. The other point I wanted to make is that the city's approach also, excluding this project, the Turning Basin project, is contrary to their approach as the other projects. So at page AR 803, this is in the draft EIR, the city notes that their approach to the cumulative impacts analysis included projects with pre-application discussions underway. So it wasn't necessarily projects that were undergoing an environmental impact report. This was pre-application discussions, where the Turning Basin project was even beyond that point, not just a pre-application, but they had engaged in the study, expended money to take that first regulatory step.
Let me ask, in terms of that, you said they've spent money in study. Had something been issued to the public or something that is in the record that indicates how far they had gotten during the EIR process here?
I would say two things. First, there is a quote. This is in the city's response to comments, and this is at AR 11333. And in the response to comments, where many members of the public wanted this analyzed, the city said, the port has entered into a feasibility cost share agreement with the U.S. Army Corps of Engineers for the Turning Basin project. I think there's some evidence, at that point, and even earlier, that there had been money expended, that there was this environmental assessment and feasibility study underway. But the problem here, and your question brings me back to the problem, is that this information wasn't disclosed to the public in terms of how far along the project was. It's the port's project, and they would have been able to provide that information to the city. So when the final EIR responses to comments were released, the very same day, the feasibility study was released. And so it's a little difficult to understand why there wasn't more disclosure to the public of the status of that undertaking.
Can I ask you one other related question? In your request for judicial notice,
yes,
you asked for Exhibit C, which is the NOP, which came out May 31st. The respondents object to this in part because they said It's outside of the record.
Yeah.
It's also not relevant. It's just because of it's much later. Why should I consider that at all?
Excellent question. Well, it is relevant to the reasons I've discussed because the Turney Basin project, I think the estimate is 2.5 years of construction. This is overlapping construction that would occur on the project site. Without question, there would be a significant cumulative impact that wasn't disclosed now for purposes of the analysis of this ballpark project.
You're looking at a cumulative impact that exists, that to the extent it exists, is something that is documented after this is over. Why should I ever go there? I mean, we've learned lots of things since you've had this project. That doesn't automatically reopen it.
I'm sorry, I missed the first part of that.
We've learned there's always new things that we learn afterwards, but this is a report that came out substantially after the EIR process here. And normally I don't consider anything like that. It's not part, not only is it not part of the administrative record, it's not even the same time period. So I'm having some trouble understanding. I understand your arguments about the port should have known, the port should have disclosed, things were far enough along. That's all something that happened arguably during the EIR process, but you're citing a report that is after the EIR process. And I'm having trouble understanding why I should consider that.
Okay, sure, understood, Your Honor. It's because there are exceptions. They're narrow, but there are exceptions to the extra evidence rule. And so I would just say, you know, the WISA case itself.
Which case, I'm sorry?
I'm sorry. The Western States Petroleum Association.
Western States, yes.
Superior Court. You know, in that case, it stated that extra record evidence may be admissible for background information or when ascertaining whether the agency considered all relevant factors or fully explicated its course of conduct or grounds of decision. So even just within the meaning of that case, I think that the NOP should be considered and is relevant. Also, with respect to two of the cases that the city cited in their opposition to our request for judicial notice, also note exceptions to the extra evidence rule. So the Porterville Citizens or Responsible Hillside Development case noted that there's an exception for background information, as already mentioned, and in unusual circumstances, extra record evidence can be admissible for limited purposes. Those purposes aren't enumerated. But here, I think there is an unusual circumstance because of the location of the project, because the port itself is a sponsor of the project, and there could have been information. There was no reason that they could not have gathered and provided more information to the public throughout the EIR process. And then the second case also cited in the city's opposition, the Santa Teresa Citizen Action Group, also noted an exception for procedural unfairness. So again, I think that these decisions and the exceptions to the extra evidence rule should apply here.
I'll acknowledge there are exceptions. What's making it a little hard for me to deal with, though, is the timing and content of this document. I can certainly understand if during the EIR process there was a document which demonstrates the concreteness of a project or something like that, even though it's not in the administrative record, but it's disclosed later. Mm-hmm. I get that. I understand that. It was something that was known then, should have been dealt with then. I also understand general background. That's fine. But we're not talking about general background now. And we're also not talking about a document, at least you haven't cited any part of this document, that reflects what was known during the EIR process. You can certainly make your argument about timing without getting into that document. You talked about that earlier, and a feasibility study and the like. So I'm not inclined to consider that later document, but I just wanted to make sure I understood your position on that. So anything further before I turn to the other side?
I don't want to repeat myself, and I understand where you're coming from, but I guess I would say, I just think extremely coincidental that the same day that the final EIR is released is the same day that the feasibility analysis is released, which finds that the project could go forward and is probable, which ultimately led to the EIR.
But that's an argument that doesn't need this document.
I'm sorry, Bob. I'm sorry.
That's an argument that does not require your Exhibit C, does it? The timing.
Yeah, it probably doesn't. You're right. I would agree with that.
All right, go ahead. All right, thank you. Let's hear from the other side. I'm sorry?
I was just saying thank you for letting me go on so long.
No, yeah, important stuff. I'm happy to hear the argument.
Right. Thank you, Your Honor. Charity Schiller for the Port of Oakland. Also, thank you very much for the very detailed tentative. We all received that and really appreciated all the time and effort that went into the preparation of that. It was extremely helpful. So thank you for that. A few responses. First, with regard to whether the petitioners, and I should say EOSA, whether the EOSA petitioners exhausted their administrative remedies, they did cite to a number of comment letters that essentially say that the Turning Basin project should be part and parcel of the overall Howard terminal development, but none of those comment letters raise the cumulative impact issue that is specifically briefed by the petitioners. And so we just want to go on record with that we do not believe they've exhausted their administrative remedies. On the merits, though, this argument still fails and the tentative should stand as written. As the court noted, the notice of preparation for the project was issued in November of 2018, and the city exercised its discretion to look at what projects were reasonably foreseeable and probable at that time. That is exactly the approach that was used and upheld in the South of Market Community Action case, which is not cited in the court's tentative, but we did want to point that out. That case also confirms that that determination and the methodology used by the city is a matter subject to the substantial evidence test, which gives great discretion to the city's conclusions. And that is important because, as Ms. Wright just pointed out, there is no hard and fast rule for which projects go into a cumulative impact analysis and which ones do not. And thus, because we have case precedent confirming that the city's approach is appropriate, this court should stand by the tentative. I also, Your Honor, want to respond to the issue of, does the preparation of a feasibility study somehow make the Turning Basin project a probable project? And Your Honor, it does not. The EOSA petitioners conflate what is a theoretical possible project with what is a probable project. And the standard is what is probable. In the Gray versus County of Madera case, which Ms. Wright referenced, and also in the City of Maywood case that are cited in the papers, mere awareness of proposed expansion plans or proposed development does not necessarily require the inclusion of those projects in an EIR. Rather, the projects have to be probable. Your Honor, we do object, as noted in our opposition to the request for judicial notice, to both Exhibits B and C. Your Honor is quite correct. Exhibit C post-dates even the project approval by a couple of months. But even were the court to look at one or both of Exhibit B and C, they do not show any inconsistency with regard to the arguments we have made. They do not show that the EIR is wrong. In fact, to some extent, they actually confirm that this project, the Turning Basin project, is not probable. The feasibility study merely looks at whether the project is potentially feasible. The feasibility study is not yet done. I mean, at the exhibit that is included with the RJN is simply an agreement to prepare one. We do not know yet whether the court will formally move forward with the project, and the notice of preparation for it was issued months after the project approval was issued. Your Honor, the City of Maywood case at 208 Cal App 4th at page 398 confirms that where future development is unspecified or uncertain, no purpose can be served by by requiring an EIR to engage in sheer speculation as to its potential future environmental consequences. And that is what the petitioner is asking here. They're asking the city to engage in sheer speculation about whether the turning basin is feasible, what it might look like, what its potential impacts are, and to account for those as part of a cumulative impact analysis.
Can I back up for 1 second because I want to make sure I'm clear on the exhibits. The petitioner referred to the feasibility study that was issued the same day as the EIR. Is that Exhibit B that we're talking about to the RJN, or is that some other document?
Your Honor, yes, my understanding is that is Exhibit B to the RJN.
And your argument is that all Exhibit B says that's just an agreement to do a feasibility study. It's not the actual feasibility study?
It is a draft feasibility study, Your Honor, but the final feasibility study is not yet done. So this is a preliminary draft that sort of sketches out some concerns and issues and questions that need to be addressed before the port can decide whether or not the project actually is potentially feasible.
All right, thank you. That clarifies it.
Your Honor, two more points, if I may. One is that petitioner argues that the EIR should have done more with regard to talking about the turning basin project. And what is perplexing in part is that every section of the EIR is set up to set forth the environmental consequences of the proposed project. And then it includes a discussion of the maritime reservation scenario, at least insofar as what the project would look like if, in fact, the maritime reservation scenario is determined to be feasible and goes forward in the future. You could see that, for example, in the biological chapter of the EIR at administrative record page 119 through 1120. Additionally, each resource section of the EIR ends with a discussion of cumulative impacts, which includes a review of the project as well as all cumulative projects that are on the city's list. A part of that discussion includes a layout of what the project's cumulative impacts may be if the maritime reservation scenario proceeds. And that can be seen as an example in the biological resources discussion at administrative record page 1120 through 1128. And so, Your Honor, contrary to the arguments made on reply, the city's inclusion of a discussion of the maritime reservation scenario does not show inconsistency. It demonstrates diligence and transparency. As Ms. Dively said, it was the city's attempt to disclose everything that was known at the time. It doesn't show that the city was hiding information. It shows the contrary. They were trying to lay out everything that they knew. They just didn't know very much about the maritime reservation scenario, and they still do not. So, Your Honor, I think those are all the points that I would like to raise in response to petitioner's argument. We would ask that the court stand with its tentative.
Okay, any brief response, Ms. Wright?
Sure, very briefly. First, I just wanted to note that our request for judicial notice Exhibit B, while it is a feasibility study, that's for the draft remedial action plan that was submitted to GPSC. So that's a separate issue. I just wanted to note that for the record. I think I've already addressed most of the points, so again, I don't want to repeat anything. Just to briefly address the City of Maywood case,
Yes.
what it's relying on. That case has nothing to do with this case. There was a freeway improvement project, and the question was whether an off-ramp may or may not be built at a certain location, and the only evidence that it might be was an email. And here, that's just not at all what we have for all the reasons I've already stated. So, with that, thank you.
All right, we've come to the noon hour, and generally I don't want to go more than an hour and a half for the court reporter or anybody else going forward. Let me just ask, what do we have left that we would do after lunch, and what any kind of estimate of time?
Your Honor, speaking for petitioners, Todd Smith, I know, wants to present on some railroad-related impact mitigation issues, and Ms. Rosegay has a brief discussion with regard to hazmat issues. hazardous materials. And I think that's going to wrap up the issues we were trying to bring before the court, other than I would appreciate not having had my wonderful Clarence Darrow opening to at least get a little bit of a closing in.
All right. And then, of course, we do have the wind issue, which I don't want to forget.
Yes, of course, but that if there's one thing absolutely right with the tentative, it is a wind issue.
So you waive argument on that one, right?
Well, except for rebuttal. Yes, we do. Except for rebuttal.
Fair enough. All right. So we're going to break till 1:30. We'll come back at that time. It sounds like we should be able to resolve the other issues in an hour or maybe a little bit longer after that. And I will see you then. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Well, they're not back yet. This is quiet. So maybe when they come back, you'll be here. Look, is there anything you want me to do? Okay, okay. No, it's quiet in here now. Okay, all right.
It's a cane. Wow. Take your cane.
Hey, folks, they're supposed to come back at 1:30, and it's 4:20. I'm going to restart this because they're going to be back in a second. That way, they'll have this restarted so it doesn't conk out. All right, be right back.
Okay, folks, come on back.
Here we are. We're back.
All right, I assume everyone is back who needs to be back. So turning to petitioners, who's going to do the next argument?
Your Honor, I think, Todd, before you go, just we've been looking for, just before the break, there was a question you asked about whether an exhibit to the RJN was the so-called feasibility study. That was Exhibit C. I think that's actually the NOP.
I actually was referring to Exhibit B.
Okay. But in terms of the turning basin project, Exhibit B, I believe, relates to the RAP and versus raw issue, whereas Exhibit C is the NOP for the turning basin project. And I thought you had asked about the feasibility study for that.
That's right. I was trying to understand, there was a reference to the feasibility study being issued around the same day as the EIR. And I'm trying to identify what document that is in the record or proposed record. If that's not Exhibit B?
I believe it's not, Your Honor, and if Mr. Mormon is on, he can probably just quickly give you the site that was in our brief where we mentioned that document ourselves.
Sure, yes, that's on in our reply brief. And I can give you the page to that in just a moment. That's our petitioner's reply brief, page 32. And in footnote 44, we include a web link to the feasibility study /EA for the Turning Basin project.
Okay, and that is a document that's not actually part of the administrative record. Is that right?
That's correct, Your Honor. Yep.
Okay.
Yes, that's correct, Your Honor. But it was available to the city at the time.
Understood.
Your Honor, Charity Schuller for the Port of Oakland. I had the same clarification, so I appreciate Mr. Van Buskirk raising that. The document that is included as Exhibit B to the RJN is also called a feasibility and remedial action plan. So I did want to clarify that for the court. We do object to that on procedural grounds, but it is related to hazards issues. The feasibility study involving the Turning Basin, which is what the EOSA petitioners have asserted in connection with their cumulative impact argument, is not yet complete. And the administrative record at page 755 says that the Turning Basin feasibility study is not likely to be complete until the end of next year, or at least sometime next year. To the extent that the petitioners are referring to the web linked item in their reply brief at footnote 44, that is both a new issue that was raised for the first time on reply, which this court should not consider, and it's also extra record evidence. So we just wanted to make those clarifications, Your Honor.
All right, thank you for the clarification.
Thank you. We just wanted you to have the right. At the end, I will explain a little better in my closing exactly why it is relevant, but that's, at least we have the record straight.
I appreciate that. All right, let's move on. So what's our next argument?
Good afternoon, Your Honor. Todd Smith on behalf of Capital Corridor Joint Powers Authority. I'm going to speak today about the rail safety-related mitigation issues, specifically the issue that CCJPA raised related to the city's, in our view, failure to consider the temporary closure of the at-grade crossings as a mitigation measure, which the court addressed in its tentative in section B6. Before I get to the specifics of our objections, there are issues with the tentative. I did want to just set the table a little bit in terms of my client's interest here. And I think it's self-evident from both the name as well as the pleadings and the briefing that CCJPA is a public agency. It's got a significant regional role in terms of providing rail service across 8 counties, 170-mile rail corridor. And of course, as part of that, it deals with at-grade crossing issues and safety of at-grade crossing issues at dozens of these in areas throughout its 8-county region, including specifically Jack London Square, where there is, as the court is aware, 8 such at-grade crossings. The CCJPA is a transit agency. It benefits from ridership. This project, in theory, will increase ridership. CCJPA does not oppose this project, has never opposed the project. But as part of its role as the provider of these rail services, its obligation is to ensure safety and reliability to its ridership, and also to pedestrians, bicyclists, and motorists who cross the at-grade crossings. And it approached the process of commenting on the EIR with this obligation clearly in mind, because it's deeply concerned that adding 30,000 pedestrians and bicyclists and others to the project area, which is already a dangerous area, and a lot of 30,000 ballgame attendants will undoubtedly be under the influence of alcohol, will significantly increase the risk associated with the interaction between trains on the one hand and pedestrians, bicyclists, and motorists on the other. That is a regular occurrence. And that unfortunately does lead to fatalities throughout the corridor on a basis that is not comfortable for anybody. There's no dispute that the activity caused by the project is going to exponentially exacerbate the risk to public safety associated with these at-grade railroad crossings. What is at dispute? What is in dispute, and what I want to discuss with the court is whether the city considered in its EIR all feasible mitigation for managing these risks. And I'm here to argue that, in fact, it didn't, and that the court's conclusion in section B6 that the city was justified in not including an analysis of the temporary closure of at-grade crossings during game days or during major events was justified by the record. So there are, we believe, several flaws with the tentative decision, which I'll go through now. First, the tentative decision cites Mount Shasta Bioregional Ecology Center, which is at 210 Calop 4th 184, and it pin cites page 199 for the proposition that, and this is a quote from the tentative, quote, "The city is not required to consider various iterations of the same proposal," end quote. The issue here, Your Honor, is that the portion of the Mount Shasta decision cited in the tentative relates to alternatives analysis, not the development of mitigation measures. As a statement of law regarding the analysis of alternatives in an EIR, we do not disagree that an EIR need not consider every iteration or variation of an alternative to be valid. But this rule does not apply to mitigation measures. Rather, when it comes to mitigation, an EIR is required to consider all facially feasible mitigation measures that could lessen a significant unavoidable impact. And this principle of law can be found in numerous cases cited in our briefs, including Center for Biological Diversity versus Department of Fish and Wildlife, which is 62 Cal 4th Act 231, and also Sierra Club versus County of Fresno, which can be found at 6 Cal 5 at 524, 525. So here, the issue is not that the City Council considered all facially feasible mitigation measures and made a policy decision to reject certain mitigation measures. Instead, the issue is that the City Council was never given the opportunity to weigh the potential benefits of a mitigation measure that requires temporary closure of the at-grade crossings against any of the purported economic or other impacts associated with that temporary closure. This is because the EIR simply fails to include and analyze this facially feasible mitigation measure in clear violation of basic CEQA principles. Which brings me to my second concern with the tentative. The AR sites in the tentative, which report to show that the EIR considered the temporary closure of some or all of the at-grade crossings during game days, in fact, makes no reference to temporary closures whatsoever. Instead, the analysis in those sections focuses on the permanent closure of the various at-grade crossings and or the construction of an above-grade crossing or flyover at various locations. So, for example, Your Honor, the tentative cites to two different documents in the administrative record. The first one to look at would be AR 88925 through 88926. And this is a memorandum prepared by Fair and Peers dated January 10th, 2022, very late in the process. And the subject of that memorandum is at-grade rail crossing closures to motor vehicles. And I'm going to quote, Your Honor, I'm going to read the first paragraph of this because it makes clear what the scope of the memorandum actually is. Quote, "This memorandum summarizes the consequences of closing all at-grade railroad crossings in Jack London District, including Clay Street, Washington Street, Broadway, Franklin Street, Webster Street, and Oak Street." Continuing with this quote, "This memorandum focuses on motor vehicle traffic circulation because grade separating these crossings would be infeasible without removing existing buildings, prohibiting property access along each corridor, and closing existing streets that run parallel to the railroad tracks." End quote. Clearly, this memorandum is focused on closure of all of these at-grade crossings permanently and the construction of grade separations. That is not the mitigation measure that was suggested by CCJPA, or it was one of the mitigation measures that was suggested by CCJPA, but it's not the one that I'm here arguing today. Excuse me, sorry, Your Honor. I apologize.
That vote doesn't count, though.
Yeah, she was silent all morning, and then of course when I start speaking, she gets up. She wants attention. So going back to my argument, to demonstrate that that was not the issue that was raised by the by CCJPA, or not the sole issue, I point you to AR page 8289, which is an excerpt from CCJPA's comment letter. And the comment in question falls under the heading pedestrian and bicycle overcrossing. So nothing to do with motor vehicles. The motor vehicles are obviously part of the equation as well. And the entire paragraph discusses, or the impetus of the entire paragraph is to ask the city to consider mitigation measures that will promote pedestrians and bicyclists in particular to use the proposed flyover. And what the paragraph ultimately concludes is, quote, the most effective and safest way to direct pedestrians and bicyclists to the flyover is to close at-grade crossings, whether temporarily or permanently. The city ignored the temporary part of this comment altogether. The Fair and Piers memorandum, which is cited by the court's decision, ignores temporary altogether, as does the response to comments, which is cited by the tentative decision. Permanent closure and temporary closure are fundamentally not the same thing. And the fallacy of the city's argument, which respectfully we think the tentative erroneously adopts, is that the impacts associated with permanent closure are exactly the same as those associated with temporary closure, and that somehow this justifies the EIR's failure to consider or analyze the proposed mitigation measure to temporarily close the at-grade crossings during events. But this is frankly nonsensical, Your Honor, because as we know, words have meaning, and in this case, the words permanent and the words temporary have the exact opposite meaning. So a mitigation measure requiring temporary closure is not simply a variation of one requiring permanent closure, even if that were the standard, which we, as we have said, it is not. It's a wholly different mitigation proposal. Even if some of the impacts associated with the permanent closure might be similar to those of a temporary closure, there's one fundamental difference here that the EIR doesn't acknowledge, the response to comments don't acknowledge. Any impacts to local streets, businesses, or otherwise associated with the temporary closure of some or all of the at-grade crossings during major events would not be permanent. Instead, these impacts would only occur for a few hours a day, approximately 81 times per year. That is a far different scenario than the one outlined in the Fair and Piers memorandum and the one outlined in the city's responses to comment. What we do not know, unfortunately, because the EIR neglected to analyze this as a potential mitigation measure, is whether the temporary closure of the at-grade crossings during major events could have significantly lessened the number of interactions between trains on the one hand and people, bikes, and cars on the other, such that the trade-off between the temporary impacts to the local community might be worth it in order to reduce the number of potential fatalities that could result from this project as a result of these interactions. It's fundamental to the purpose of CEQA to disclose this type of information and analysis so that the decision makers and the public can understand the trade-offs associated with the given project. Here, the EIR fundamentally failed to disclose these trade-offs because it failed to include analysis of a facially feasible mitigation measure that would have required temporary closure of the at-grade, some or all of the at-grade crossings during major events. So the next issue I'd like to raise with you, Your Honor, related to the same topic, is that the tentative relies upon, or at least quotes, the fact that there's a proposed fencing along the rail corridor as a check on the risk to public safety. But the fencing along the railroad right-of-way is an illusory mitigation because UP, which owns that right-of-way and has absolute right to deny anyone the right to do anything, has made clear that it's not going to authorize the city to undertake the construction of the multi-use path and other related improvements in the railroad right-of-way. But even if this weren't the case, the fact that there is some mitigation in the EIR that addresses the impacts to public safety does not relieve the city of considering other facially feasible mitigation. Again, this is not an alternative scenario where you only need to have one. The city had a duty to consider all facially feasible mitigation measures that would minimize the significant unavoidable impacts to public safety, and it failed to do so. The last point I'd like to make, for your honor, is that the tentative did not consider a case cited by us in our briefing that we think is certainly dispositive of this issue and would require the court to find the city abused its discretion here in failing to consider and analyze the proposed mitigation measure. That case is Los Angeles Unified School District versus City of Los Angeles, 1997, 58, Calat 4th, 1019. And in that case, the expert agency, the LA Unified School District, who builds schools and has thousands of students, in its comments on the draft EIR prepared by the respondent, City of Los Angeles, suggested that the lead agency should consider installation of air conditioning units as a mitigation of an impact to the student body. The lead agency failed to adequately respond to that comment or to consider the proposed mitigation in the EIR. The court found that this violated CEQA and set aside the EIR. Here, CCJPA commented that the city should consider temporary closure of at-grade crossings as a feasible mitigation measure to the public safety risks caused by the project. This, as I said, this comment appears at the end of a section where the whole purpose of the comment is to instruct or guide the city on productive ways to remove pedestrians and bicyclists from at-grade crossings to the flyover, which is significantly safer. The city failed to respond to the temporary part of CCJPA's comment and therefore failed to consider temporary closure as a form of mitigation. We believe, Your Honor, we respectfully submit that the LAUSD case dictates that the city's actions in this regard clearly violated CEQA. And I would urge Your Honor to reconsider the court's analysis of this topic and the tentative with this case as well as the other points that I made clearly in mind. Thank you.
Thank you. A response?
Good afternoon, Your Honor. Tim Kremen. I'll be responding to the rail issues that were raised by Mr. Smith.
Okay.
There's a little bit of a host of them, but starting on the alleged comment proposing a mitigation of temporary closure of at-grade crossings. I'd like to start by saying that they have the burden of establishing that they exhausted administrative remedies. As he stated, they're in the business of providing commuter rail. When we raised our opposition brief, where was this raised? The only site they pointed to was a single one, which is at AR 8289. That site has one sentence that has one word that says temporary, and the sentence reads, the most effective and safest way to preclude the possible use of at-grade crossings is by closing them, whether temporarily or permanently. So I will ask them to point where the word temporary closure appears elsewhere in the record, but we have not found it, and it's their burden to establish they exhausted. And in addition,
let me just make sure I'm clear on what you're saying. That site 8289 is in their brief, or are you saying it's in the, where are you saying that site is?
it's their comment letter.
Their comment letter. Okay. There's a reference here to 88925 to 26. What about that?
You have to give me a second to pull that up because I don't think they've cited that before.
Okay.
So with apologies, can you read that again? 89.
What I thought it was is 88925 to 926. Mr. Smith, is that correct?
It is, Your Honor, and that's the AR cited from your tentative decision. So that's why I was discussing it. But the evidence that you cited in your tentative decision, which is from the administrative record, that's why that citation came up. I did not report, as Mr. Kremen seems to imply, that somehow I had cited that in my brief. That's not the point at all.
Okay. So the argument then is the only thing cited in the brief is 8289. Is that what you're saying, Mr. Kremen?
Yes, and I did check 88925, and I agree that Your Honor cited it. along with another one, but the word temporary is not in those other signs.
Well, assuming arguendo, the only thing I should look to is A289. It does say temporary, doesn't it?
It does, but if you listened to the argument that was made before you today, that argument wasn't made before the city. I mean, he made a big deal about, well, the city didn't have the, did not consider this and so on and so forth. But the reason that, you ask the city to consider stuff first rather than the court is so that the city has the information that's needed to evaluate it. They have the burden to establish exhaustion. I really strongly feel that the case law support that a single word in a single sentence by an agency that submitted a lengthy comment letter, appeared at public hearings, submitted a letter on the day of the city council action that did not have the word temporary in it. That is not exhaustion of administrative remedies. I'll leave it at that because I want to move then to the remedies, but I really do feel like no way does that exhaust remedies and give us an opportunity to meaningfully consider it in whole part. Second argument I want to make is about the word temporary. He says, well, temporary is clearly not permanent. And then went on to say, well, temporary here would be 81 baseball games a year. That's, to me, that's not really temporary. I mean, you have to look at what they mean by temporary and why it moves closer to a permanent impact than a temporary impact. They've already conceded they're talking about crowds for baseball games. That happens 81 days per year, or 81 games, they make the playoffs more. Then if you look at the traffic analysis looks at arrivals and departures for 2 hours before a game, 2 hours after a game. So it's this period of like 3 p.m. to 8 p.m., which is prime time for not only people commuting to and from their homes, but also in the Jack London Square area, there are restaurants, there are drinking establishments, there are theaters, there's all these things. And for them to say, wait, temporary is completely different from permanent just isn't true in this case. They're talking about 8 intersections that provide access to all kinds of businesses and where people live, hotels, restaurants. And so I think there's a bit of a fallacy, even if we accept their exhaustion, about, well, this temporary is not really permanent. And that moves me to why, which I think the tentative ruling correctly established, that where the record analyzed the effect of closures, that a lot of those effects don't have a temporal element to it. I think that is the key thing that the court's tentative kind of locks in on, which is, okay, in the record, there's all this evidence about permanent closures, okay? And it is summarized street by street at AR 12321-12323, which provides a good summary based on the technical reports. The technical reports are cited in our brief, but I think it's a good summary street by street of what the impacts are. And the court in its tentative, again, looked at this and used examples of certain streets and why those impacts would be significant because of access to business and otherwise. And I will just say, to build on that, to summarize what was in the site I just provided you, for the Jack London Square businesses and restaurants, they lose customers. There are restaurants, hotels, and stores. There's owner and tenant access. There's delivery access. There's boat slips in that area. And transit runs down 12th Street right into Jack London Square. And so if you're saying people can't walk across the street, or he keeps going back and forth between, well, we're really talking pedestrians, or we're really talking pedestrians, bikes, and cars. To me, go back to the comment, unclear what they mean. I think they meant it all because that's what they said. So Jack London Square has significant impacts Oak Street has significant impacts because it is the one street that comes from downtown across the railroad tracks to Embarcadero, which is the main waterfront street that goes to like Brooklyn Basin and other waterfront uses. Your Honor, you mentioned Clay Street. Clay Street has a fire station on the other side of the railroad tracks. All these streets are cul-de-sacs. There's a ferry terminal. If you're saying people can't walk across, again, I object to it being limited to pedestrians. If you're saying people can't walk across, then how do people use the ferry terminal? How do they get there? There's offices on the other side of it. It's a cul-de-sac. Your Honor's tentative says all this. I will also mention one thing that Mr. Smith doesn't say is that in the record is a vision plan that was drafted by CCJPA. And it talks about various ways to deal with the rail corridor in Jack London Square. And in their own vision plan, they reject improvements that result in barriers isolating Jack London Square or other existing land uses on the other side of the tracks, because that would be infeasible. So they've like looked at how to solve this existing problem in the past, and they, by their own words, have concluded that doing measures that isolates Jack London or the uses along the Embarcadero and the waterfront is infeasible. And that site is 87318 and 45017.
All right.
So, and I just want to go back to make sure there's some other points. On the law about Mount Shasta versus all feasible mitigation measures, I don't think there really is a dispute about the standard that applies here. Since the impact is significant and unavoidable, and that is what standard the city applied, it is a requirement under the law, and we don't argue otherwise, that we have to consider all feasible mitigation measures. We did that. Like I said, there's extensive information in the record about the infeasibility of closures of these streets. And although with respect to the tentative ruling in the Mount Shasta site, I will say that the tentative ruling is consistent with the law and how it does the analysis, which is that, you know, we have to show that the proposed mitigation measure is infeasible to support a significant unavoidable impact. And the other part of the significant unavoidable conclusion, when he talked about, well, you know, the city doesn't have an opportunity to evaluate trade-offs between these mitigation measures and other benefits of the city. Well, when you have a significant unavoidable impact, as we do for rail safety, and they find a mitigation measure or alternative is infeasible, the city's obligated to adopt a statement of overriding considerations. And that statement of overriding considerations does exactly what Mr. Smith said should be done, which is weighs the benefits of the project against the adverse environmental impacts. The city followed the law and adopted a statement of overriding considerations that weighed those and identified, not only weighed, but identified the specific public benefits that override the adverse impacts of the project on rail safety. And I guess I just close by saying that, you know, in this instance, I think it is difficult to say, based on the record, that the city did not consider everything feasible it could do at these rail crossings. There's an existing condition out there which is dangerous. There are no between intersection protections of the rail line. There are minimal at intersection protections. What the project has done, in not understating the impact, has proposed extensive improvements throughout the corridor that are currently unprotected. And they've done that from not only the project frontage, but all the way down to Oak Street, which is about a mile away. And it involves 8 crossings, and it involves gates at the intersections, fencing at the crossing. He made a reference to the multi-use path. There was kind of a short argument. I can address that quickly, or ask the court. Do you have any questions, or I can move to just addressing the multi-use path briefly?
Go ahead.
Okay. So it sort of piggybacks on an argument that UPRR makes, which, you know, the premise just can't be accepted, which is they start the argument by saying it's illusory because UPRR says they're not going to allow it to happen. I mean, we wholeheartedly reject that premise, and we say that in an opening brief. You have a current situation where the railroad right-of-way is in a public street. Cars drive in the railroad right-of-way. People walk in the railroad right-of-way. The multi-use path mitigation measure says the multi-use path would, and this is the critical one, replace the vehicle street that exists today. That's at 1809 and 1912. So, you know, the premise has to be rejected. You know, UPRR, who isn't here and didn't contest the tentative, and I'll close with a statement on that. So CCJPA says, well, they say yes, you know, that has to be accepted as gospel by the court. It's simply not true. I mean, the evidence of the record shows there's fences in the right-of-way. There is an existing street in the right-of-way. And so, as the court pointed out, the EIR fully disclosed, and I don't want to read the court's tentative on this, but the court rightfully concludes that, hey, the EIR says these feasibility concerns were raised. They're fully disclosed. It's subject to a regulatory agency approval process, which is the California Public Utilities Commission. And at the end of the day, you know, the determination of the final measures would be made by that regulatory agency. In fact, when the city said significant or avoidable, it isn't only because people will continue to use at-grade crossings, it's also because it's subject to approval by another regulatory agency, like the city can't have final approval. The tentative rightly says this is all that CEQA requires. I mean, you know, we identified the feasibility issues. It's stated in the mitigation measure, full disclosure, subject to another agency approval. And so I think that's covered consistent with the court's tentative. Can I just close on UPRR issue? They're not here, but since we don't get rebuttal, I think this is critical to state to the court. I mean, you issued a tentative ruling in all 3 cases. UPRR is a separate case. They did not contest the tentative. No one has appeared on their behalf. If you read the opening brief, the only claims they joined in were the rail claims and recirculation. So we just want to say to the court that based on where we stand today, when this hearing concludes, we ask that judgment be entered denying the writ in its entirety in the UPRR case because there's nothing left. They didn't contest it. And the wind mitigation issue, which is the one thing we're talking about, they did not join in that claim.
It's not their issue. I understand.
Yeah. So if any questions available, otherwise I think that responds to Mr. Smith's.
Okay. Mr. Smith, brief response, Benny.
Yeah, I'll just hit a few points quickly, if I may, Your Honor. On the issue of exhaustion of administrative remedies, the city seems to be trying to hold CCJPA to a standard that doesn't exist in law. That they said that we only raised the issue of temporary closure in one place. Show me a CEQA case that says that CCJPA was required to raise in its comment letter this issue in multiple places. It doesn't exist. The comment letter on the draft EIR is where CCJPA raised its substantive comments on the issues related to rail safety and mitigation of at-grade crossing impacts. The section of the letter which Mr. Crevens and the city in their brief attempted to, or the respondents and city attempted to refer to as isolated and out of context, In fact, it's not isolated and out of context at all. There's an entire paragraph under the heading pedestrian and bicycle overcrossing. And the whole point of the paragraph, if Your Honor decides to take this under submission and review it again, Your Honor will see that it's about incentives to move people from bicycles from the at-grade crossings, which are unsafe, as admitted in the EIR, to the flyover. And at the end of that, the summation of that is the safest and most effective way to achieve the goals that we've just outlined in the above paragraph is through the permanent or temporary closure of at-grade crossings. The city ignored the temporary part, and now they want this court to ignore the temporary part and give them a pass, but that's not how SWECO works. The comment is there. They have a duty to respond to the entire comment, not just the parts that they feel satisfied responding to. And their efforts to try to make this an exhaustion issue is pretty specious. The second point made was that Mr. Kerman spent a significant amount of time arguing about the feasibility and the impacts of temporary closure. Well, that's what it should have been done in the EIR, and wasn't. That's the whole point of our petition and our arguments in the brief on this particular topic, is that having been given this option, this idea to consider temporary closure as a feasible mitigation measure, it was the city's duty in the EIR to respond to that and specifically either reject it or consider it as an EIR, and they failed to do so. Next, the summary, the street-by-street summary, as I already said in my opening points, doesn't mention temporary. It's focused on the permanent closure of all the at-grade crossings, and it's focused on the construction of flyovers, which would change that dynamic. That is not what a temporary mitigation measure would look like. And to that end, Mr. Crimmins implied, or not even implied, said, well, CCJPA should have just told us what they wanted. It's the city's job to develop mitigation measures. We gave them the idea based on CCJPA's expertise. The city had the obligation to go then and figure out what that mitigation measure looked like. It is not the job of the public or a commenting agency to write their EIR or their mitigation measures for them. On the issue of the vision plan, this is a red herring, Your Honor. The vision plan didn't have any idea there was going to be a baseball stadium and there were going to be 30,000 drunk patrons crossing the at-grade crossings. And the fact that the vision plan happened to address not wanting to isolate one side of the right-of-way from the other isn't inconsistent with the temporary closure during the specific events when 30,000 drunk patrons are going to be traversing these various at-grade crossings. So the vision plan is irrelevant, and the existence of the vision plan does not in and of itself excuse the city's duty to analyze all feasible mitigation measures. So I don't disagree with Mr. Crimmins that the purpose of a statement of overriding considerations is you balance the policy issues and make decisions. But this statement of overriding considerations did not balance the policy issues associated with a temporary mitigation measure which requires temporary closure. It only balanced the policy issues associated with permanent closure and the construction of highly flyovers. And I guess with that, I guess I would just close by saying that, obviously, Your Honor has any questions for me, I'd be happy to answer this. But, the city doesn't get extra credit for having identified that their project is going to bring 30,000 patrons to this already dangerous situation and exacerbate it considerably. And so then they propose some improvements. That is their fundamental job. It is their fundamental job in an EIR to look at the impacts that their project is going to cause or exacerbate and to do something about them. And our argument here is not that the things that they have done don't somehow improve things or not improve things. That's ultimately another decision. Our argument is they didn't consider everything that could happen they were required to by law. And with that, I'll leave it, Your Honor.
Thank you.
Your Honor, can I just add one brief thing? And it's simple. It's just on the exhaustion issue. We brief it on page 32, and we cite City of Orange, which says isolated and unelaborated comments do not fulfill CEQA's exhaustion requirements. So I just want to say that. Thank you.
Fair enough. All right, let's go. Next argument. What is it?
Your Honor, it's for the petitioners, it's Ms. Rosegay with regard to hazardous materials issues.
Okay, thank you, Ron. Good afternoon, Your Honor. I will be addressing the issues that are in section C2 of your tentative, dealing with chapter 4.8, hazards and hazardous materials. And there are 4 specific issues that I'd like to touch on.
Let me just catch up here. Hold on a second.
I'm sorry.
This is in section C2.
C2 of your tentative, which I believe starts at page 20. You don't have page numbers, but I wrote them on your decision.
Sure,
20 or actually, yeah. Is that right? Yes. Begins on page 20.
Is this the removal, or which issue is this on?
Yeah, well, this is the basket of issues that deals with the site contamination, and it does include both the issues of the RAP versus the RAW, if you will.
Yeah, okay.
Use the department's acronyms. So there are 4 issues really here. They're quite interrelated. One is obviously the deficiencies in the discussion of remedial measures. The second is the subject of deferred mitigation. The third is the complete omission of a category of chemicals called hydrocarbon oxidation products, or HOPs, as constituents of concern at the site. And the last, and very related to the HOPs issue, is the respondents' reliance on an outdated ecological risk assessment. So on each of these issues, we do believe that the tentative is in error and should be reversed. So let me give you a quick overview of each of these issues, and then if time permits, I can get into a little bit more detail. So the first one, the discussion of remedial measures in the draft EIR is very general and open-ended, leaving the public substantially in the dark as to how this very large and contaminated site will actually be cleaned up. Respectfully, petitioner believes that the court's tentative, i.e. that the EIR presents sufficient information on this issue, should not stand. The inadequacy of this decision is made evident by the nearly contemporaneous 300-page draft remedial action plan dated January 18, 2022, that was submitted to DTSC just 1 month after the FEIR, the final EIR, was released. The city surely knew that this document was underway, and it contains important information that should have been included in the EIR. In fact, review of the draft RAP reveals that it is likely a modified version of the RAW that was in fact referenced in the draft EIR. This conclusion is supported by the cost of the preferred alternative identified in the RAP. That's at page 43. It comes in with a price tag of $1.77 million, which is just under the $2 million statutory cost threshold for removal actions under Health and Safety Code section 25-356.1. And lest we hear an objection based on failure to exhaust, this cost issue was raised on page 53 of petitioner's opening brief at footnote 74. So as an aside, I'd also like to mention that the RAW itself existed or was underway at the time the draft EIR was made available for public comment, and even that document was itself not included in the EIR. So at a minimum, the point we're making is that respondents had a duty of investigation under CEQA to determine whether additional information about the cleanup was available for inclusion in the draft EIR, and if necessary, to delay the release of the EIR until that information became available. If, on the other hand, the city was unaware of the A's work on the RAP and only became aware of it after the close of the comment period, it should have included this information in the EIR and recirculated the document for further public review before proceeding to the hearing in February. This was not done, and it belies Ms. Dively's earlier statement to the court that respondents analyzed as much as they possibly could. So the importance of this failing by respondents cannot be overstated, as some of the information in the RAP actually conflicts in important ways with information that's in the EIR. Specifically, in the amount of contaminated soil that is actually proposed to be removed from the site, as opposed to just reburied somewhere, and the way in which target cleanup levels are used. While the A's seem to be of the view that any deficiencies in the EIR can be overcome by their decision to proceed under a RAP rather than a RAW, that decision was made after the close of the public comment period and mainly serves to underscore the inadequacy of the draft EIR. The A's do not get a gold star for deciding to do a RAP after the close of the comment period.
So let me just be clear, the RAP document is the Exhibit B.
That's correct, yes. And the confusion is, just as you noted, it is also called a feasibility study / draft remedial action plan. And I think that was the source of the confusion. So we do believe on this issue that the respondent should be ordered to supplement and recirculate the EIR so that the public is provided with enough information to gain an accurate and more complete understanding of how the project sponsor intends to proceed with the cleanup. The public's entitled to this information now as part of the CEQA process and is not required to wait until DTSC makes the draft RAP available for public review. Moving on to a very closely related issue, the tentative concludes that the EIR does not unlawfully defer mitigation, paraphrasing arguments made by respondents in support of deferral. However, the mitigation measures contained in the EIR do not contain specific, or they do not constitute, specific performance standards as required, since they are largely non-regulatory in nature and highly negotiable within the context of a specific project with uncertain outcome. In fact, there are few legally binding rules or regulations that mandate a certain outcome in any remediation project. Instead, there is a vast compendium of procedural documents, goals, objectives, policies and procedures, guidance documents, guidelines, screening levels, risk assessment protocols, etc., all of which can be negotiated and modified based on site-specific considerations and other factors with widely varying outcomes. The EIR is rife with references to these various publications, which the court has tentatively found sufficient to avoid a charge of unlawful deferral of mitigation. Petitioners respectfully submit this is incorrect, as these publications do not rise to the level of specific performance standards that yield a certainty of outcome. They may be starting points, but they are not necessarily end points. Further, as discovery of the draft RAP makes clear, it is simply not true, as stated in the EIR, that none of the details of any of these plans is known at this time. Clearly, the A's army of consultants had been working on this document for months, trying to move the DTSC process along while providing only a very general discussion in the EIR. There's tangible evidence of this concern in the EIR in terms of how the TCLs and soil gas attenuation factors are being applied at the site. In many cases, the actual measures that will be taken to mitigate significant impacts are deferred to plans that will be developed in response to yet another generation of plans, effectively double deferral. So at this point on the subject of deferral, I'm trying to speed things along here, Your Honor, because I know this is taking a long time. So we believe that the court's tentative ruling allowing deferral is in error, and that the EIR must be revised to include mitigation measures that adequately inform the public how hazardous materials related risks in each environmental medium will be reduced to less than significant. Let me turn quickly then to the subject of hydrocarbon oxidation products. This is an emission from the EIR, plain and simple. This is an entire family of chemicals that are produced when petroleum hydrocarbons degrade in the environment. They're not the same as petroleum hydrocarbons. They have different toxicity values and they behave differently in the environment than petroleum hydrocarbons. For example, they are more soluble and they have a greater propensity to migrate in the subsurface. These compounds are known to be present in site groundwater in concentrations that exceed both health and ecological screening levels established by the San Francisco Water Board. The petitioners raised the lack of information on hops in their comments on the EIR, but respondents' responses to those comments reveal a lack of scientific understanding of these compounds, or worse, a decision to withhold important information from the public.
Let me stop you there for a second.
Sure.
I'm a little perplexed by this argument because you say that it's an unscientific explanation. How am I to evaluate that? Is there an expert report that talks about that says they did something unscientifically? Or are you asking the court to make an expert judgment that they were erroneous?
No, I understand, Your Honor, that it is beyond the purview of the court to, step into the shoes of an expert and make that scientific determination. And we did not prepare an expert report, but we did our comments, and unfortunately I do not have the record citations handy, but petitioners did hire an expert, Terraphase Engineering, a highly qualified hydrogeologist named Peter Zauslansky. His information is in the record. He is an expert on those matters on the subject of hops. He has worked on numerous sites involving hops, indeed one immediately next door to the Howard Terminal. And it is his professional opinion that the respondents' response to our comments is simply fundamentally scientifically inaccurate, that these hydrocarbon oxidation products cannot be analyzed as if they were mere petroleum compounds. Okay. So I think it's also, the tentative also notes that there's no information to support the claim that the extent of hops is greater than the extent of total estimated impacted groundwater as described in the EIR. And if I can take just a second and ask Eric if he's on the line. Eric, can you please put up quickly yes, okay. So figure 4.8-4 is from the EIR, the record site 1349. The figure next to it represents the distribution of hops in the groundwater at the Howard Terminal based on an analytical procedure that will reveal the presence of those compounds in the water. And then figure 13, if you could move to the next, there we go. This figure, likewise from the site investigation report at AR 79338, is the depiction of the extent of petroleum hydrocarbon contamination when analysis is performed without silica gel cleanup. And if you perform that analysis with and without, or this is done with silica gel cleanup, and that removes the hops from the sample and basically shrinks the size of the plume, if you will, to include just those compounds that show up. So we don't have a picture that overlays, if you could switch back to the previous slide, Eric. So we don't have a slide that overlays because we did not want to create any new documents, obviously. But if you overlaid figure 12 on top of figure 4.8-4, that would give you a an accurate depiction of the extent of groundwater contamination at the site. You can take down those slides now, Eric, so I can see Your Honor, please. Thank you. So this is not an inconsequential omission. This error is carried through into the risk assessment, and it results in a failure to evaluate a significant source of risk to human health and water quality. An example of a potential human health impact would be dermal exposure to these chemicals in groundwater by construction workers. And a water quality example would be discharges of dewatering water that contain these chemicals. And because hops are not identified as COCs at the site, and indeed are not even recognized by the consultants that have prepared the underlying reports, those chemicals would not even be looked for in any dewatering discharges that might or that will occur. I mean, there's no question that dewatering at this site will be necessary. One final point on the health risk assessment, and then I will conclude. So petitioners commented that the human health and environmental risk assessment that was prepared for this project is deficient because it incorporates and relies on an outdated eco-risk assessment conducted 20 years ago. This is before hops were understood to be constituents of concern and before any screening levels were even developed for these chemicals. The tentative incorrectly concludes that petitioners did not identify any deficiency with the 2002 assessment, arguing only that the screening levels had changed. But respectfully, we believe that this misses the point that we were trying to make here, which is that it is the lack of information on hops in the 2002 eco risk assessment, which makes the 2020 risk assessment the deficient document. The 2002 document was fine at the time that it was prepared, but you can't incorporate an outdated document and then claim that the latter document is sufficient. Because both ecological and human health screening levels have been developed by the Water Board, and because hops are known to be present at the site in excess of these screening levels, this information should have been included in the human health risk assessment and hops addressed as any other COC at the site. So the absence of hops in this document leads to the unsupported conclusion that groundwater contamination at the site does not pose a human health or ecological risk attributable to these compounds, which is a major omission that we believe should be subject to de novo review. Thank you, and I will reserve on other issues relating to hazards. Thank you.
Response?
Thank you, Your Honor. Whit Manley on behalf of Athletics Investment Group. And there are a variety of arguments that were made that Ms. Rosegay has not addressed. In the tentative, I'm going to focus on those things that she has commented upon. First of all, preliminarily, Exhibit B to the request for judicial notice is the draft remedial action plan that my client, Athletics Investment Group, submitted to DTSC in February of 2022. It is not part of the city's record. The reason it's not part of the city's record is a copy of that draft RAP was not submitted to the city. It was submitted to DTSC because that's the agency that will review and then subject that document to its own regulatory processes. There is absolutely nothing wrong with an applicant submitting what amounts to an application for a parallel regulatory approval in tandem with the lead agency's review of the project as a whole. There's absolutely nothing wrong with that. We were just simply working with DTSC in tandem with working with the city. It is true that the DTSC is identified as a responsible agency and it cannot act on the draft RAP until after the EIR is certified. And so, but that hasn't happened, of course. The city has certified the EIR, DTSC has not approved the draft RAP. And in fact, on top of that, DTSC, because this is a draft RAP rather than a removal action plan, will undertake its own public review process, providing another opportunity for folks to weigh in on exactly how the site will be cleaned up. but none of that makes the draft RAP part of the record. Therefore, it ought not to be considered by the court, and the request for judicial notice ought to be denied. Now, having said all that, there is nothing in the draft RAP that is of concern to us. And in fact, we pointed this out in our opposition brief. Everything in the draft RAP is consistent with information that was in the EIR. Ms. Rosegay mentioned two items that, in her view, differ between the information in the draft EIR, and the information in the draft RAP. One item was the quantity of soil that will potentially be removed, and the other is risk levels associated with target cleanup levels. And in fact, the information in the draft RAP is entirely consistent with what's in the EIR. The draft EIR included a prediction of what decision DTSC would make about what kind of cleanup ought to be performed. And that consisted of targeted removal of certain soils with higher concentrations of constituents of concern, along with consolidation of other less affected soil elsewhere on the site, and then placing an engineered impermeable cap atop it. That is the prediction that's in the draft EIR, and that's actually what the draft remedial action plan recommends to the Department of Toxic Substances Control. The volume of soil is slightly different, and DTSC will have to make a call about what sort of RAP to ultimately approve. That will be a subject to its own public review regulatory process. But the documents are consistent with one another. And I do want to note that there's a claim that that EOSA placed in its reply brief improperly. We haven't had an opportunity to respond to it, that somehow the measure of risk in the form of excess cancer lifetime risk from exposure was somehow relaxed in the draft remedial action plan submitted by the A's. It's actually incorrect. The standard in the risk assessment and in the draft remedial action plan that's been submitted are exactly the same. It's 1 × 10⁻⁶ excess lifetime cancer risk. It's the same standard. EOSA in its reply brief pointed to another standard, which is 1 × 10⁻⁴. That is a soil management standard, determining the amount or volume of soil that needs to be placed atop soil that remains on the site in the service of meeting the ultimate cleanup standard, which is 1 × 10⁻⁶. That standard has not been relaxed. That is a mischaracterization of what the draft RAP proposes. And actually, we did refer to that briefly in our answer to the amicus brief submitted by CBD. If the court wishes to see that. Now, with respect to deferral, there's a claim that somehow we should have delayed the environmental review process here in anticipation of the draft RAP being submitted. It's noteworthy that Ms. Rosegay, in making that argument, didn't cite to or respond to any of the case law dealing with deferral of mitigation in the context of hazardous material cleanup. We actually cite those cases in our papers, most notably the City of Maywood case, but also Treasure Citizens to Protect Treasure Island, and also the Mission Bay Alliance case, both out of the First District Court of Appeal, both of which make it clear, consistent with other case law generally, that compliance with regulatory standards is a common and reasonable form of mitigation. And in this instance, we followed the same approach that was upheld in those other decisions. There's a very extensive discussion in the EIR of the regulatory processes and standards that will apply to the cleanup, acknowledging DTSC's preeminent role in deciding exactly how the cleanup will proceed. We, as I said, make a prediction about what we think DTSC will do, which is to require targeted removal of some soil, plus consolidation and capping other less impacted soil on the site. And whether that actually ultimately is what DTSC does is going to be their decision to make. But they'll be making that decision against the backdrop of express performance standards. Those performance standards in this case consist of the target cleanup levels set forth in the remedial action, strike that, in the risk assessment that was subject to DTSC review and approval, basically establishing quantitative standards that must be met in order to ensure that there aren't any significant human health or ecological impacts associated with the cleanup. Those are performance standards, and those standards are available and have been enshrined in the risk assessment approved by DTSC. Those are the targets that we're going to be required, held to throughout the cleanup process. We think we know how we're going to go about doing that, and then ultimately DTSC will make the call. Now, with respect to hops, hydrocarbon oxidization products, I am not a chemical engineer. I am a lawyer. I have to concede my limited understanding of chemistry. But what I do know is what I read in the record. And the record makes clear that NGO, the consulting firm that performed the investigation and prepared the risk assessment, all under the guidance, supervision, and approval of DTSC, addressed this issue squarely. Hydrocarbon oxidation products are removed through a method that's used to actually test samples. It's called silica gel cleanup. We refer to it in our opposition brief. And the issue that's been flagged by the regional board and the Department of Toxic Substances Control is that you have to sample material, soil, groundwater, what have you, groundwater in this case, both before and after silica gel cleanup, because that process, SGC, has the potential to remove hydrocarbon metabolites. And so if you sample only after silica gel cleanup, you run the risk of underestimating the total petroleum hydrocarbons in the sample. And actually, the data here reflects that. We know that because NGO, per DTSC guidance, provided data on the results both before and after silica gel cleanup. It's all set forth in the site investigation report that was published in 2020. And that is the exact same data that NGO used to develop the risk assessment. And the target cleanup levels capture total petroleum hydrocarbons. And the data that was used to develop those includes the data from samples prior to silica gel cleanup. So the notion that somehow hops were missed in all this just simply isn't correct. They're reflected in the site investigation and in the risk assessment, and we need to adhere to that risk assessment's target cleanup levels as we go forward with the remedial action plan. In a word, hops were not missed. There's an acknowledgement that screening levels for soil gas, soil, and groundwater exceed screening levels on this site. And the risk assessment and the RAP are going to address the entire site. It's not as though we're going to cherry pick some sites and not others and not apply target cleanup levels in one place, but do apply them in the other. The TCLs apply across the site. And so in doing that and in considering the samples prior to silica gel cleanup and how we perform that cleanup, hops will not somehow be missed. Now, with respect to the reliance on an old ecological risk assessment, it is true that a risk assessment was prepared in 2002. It concluded that the constituents of concern at Howard Terminal did not present a significant risk to aquatic resources in the Alameda Estuary. And it is also true that that assessment is 20 years old. It is also true that that assessment has been revisited intermittently based on updated data, updated sampling, updated monitoring at regular intervals throughout the life of Howard Terminal over the last couple of decades. And in fact, most notably, Baseline Environmental did a 5-year review report in 2018 in which it revisited this issue of whether Howard Terminal posed a significant risk to aquatic resources. And it concluded that the assessment dating back to 2002 remained valid. And that there was no evidence that discharges from Howard Terminal represented a significant risk to aquatic resources. Unless the court has any questions, I believe I've addressed everything that Ms. Rosegay has spoken about. But if the court has any questions, I'd be happy to answer them.
No, that's fine.
Thank you.
Ms. Rosegay, do you have any comments you want to add?
Yes, just very quickly, Your Honor. So the point we're making about the RAP is that it underscores the fact that the city must have known that this RAP was being prepared. The notion that the RAP would be submitted to the Department of Toxic Substances Control in a parallel action, those are not independent processes that are taking place. The document is extensive. It's 300 pages in length, and it pretty well matches up with a RAW that was likely underway at the time the draft EIR itself was being prepared. So if the city knew this was being prepared, and even if it didn't know that it was being prepared, it had a duty to press the project applicant to determine if there was additional important information that it could include in the EIR, and it needed to delay the completion of the EIR until that information was provided. It's simply not acceptable to disregard a large volume of critical information because it's been submitted to another agency.
What is it you're saying that it is the information that was not disclosed or that would change the results? So you mentioned two things before, which was an analysis of the target cleanup levels and the amount of soil to be removed. Are those the matters you think should have been disclosed?
Yeah, those are the two principal inconsistencies that I identified from my review of that document. And Mr. Manley noted that there was I think he used the word a slight difference in the amount of soils. Well, the EIR talks about 200,000 cubic yards of contaminated soil, whereas preferred alternative number 3 in the RAP will remove all of 10,000 cubic yards. That's 5% of the amount of soil that's predicted to be removed in the EIR. And I would submit to the court that the public had a right to know that the project applicant intended to remove only a very small quantity of contaminated soil from the site and to rebury the rest of that soil elsewhere on the property. And that information was not available to the public and could only have been gleaned by including the information that's contained in the draft RAP. They don't have to have included the entire RAP, but there was important information, and the sheer length of the of the draft RAP indicates necessarily that it has far more detailed information to, portray about the proposed cleanup than is contained in the EIR, which is limited to very generalized discussions about remediation methodologies. And, maybe we'll move some, maybe we'll remove some soil, maybe we'll reconsolidate some soil, maybe we'll do vapor mitigation, and we're not doing any groundwater remediation. I mean, those are issues, putting aside the merits of the cleanup that's proposed by the applicant, that's not the issue. We understand that. The question is what information was made available to the public, and we're dealing with, it's already, West Oakland is already a burdened community. We hear that frequently. It's in this case, this community has been living with Howard Terminal for decades, and the public has a right to have this information so that it can comment on the range of mitigation measures that they believe should be implemented in the context of this massive development project. It is an opportunity for the public to make its preferences known. And without that information, they're not able to comment meaningfully.
Well, I appreciate your explanation.
Yeah.
Anything further?
I believe I've been, I think I've stated what I need to state, so I'll stop there. Thank
I
you.
appreciate that. What's next?
Well, Your Honor, on our side, in terms, except for some closing remarks, I would appreciate having a chance to make. It'll be brief. I think we're done, and so I would imagine we're up to the wind issue, which is the other side contesting Your Honor's tentative.
Sounds right to me. Who's going to argue that?
I am, Your Honor, Shay Digley on behalf of the city. This is, in your tentative, this is a C5 deferral of wind impacts, or at least that's how the court characterized it.
Yes.
That's what we're objecting to. So to start with it, actually, you know, similar to the rest of Your Honor's tentative ruling, we actually agree with most of what the tentative says with respect to how the EIR comprehensively analyzes wind and discloses the impacts and includes mitigation. And actually, the court does an excellent job of actually summarizing what is in the EIR, where it says the EIR engaged in a detailed preliminary report using a SCARE model, a proposed impact, disclosed that the impacts would be significant and unavoidable, as well as that there is unknown conditions, and then committed to mitigating the impacts through future study. And I also just want to start off that, you know, that the tentative recognizes that petitioners have not disputed that the true magnitude of future wind impacts cannot be determined until there are future specific building plans. The issue with the tentative then is its conclusion that the mitigation measure is missing a performance standard. And the tentative reaches this conclusion based on endangered habitat leagues, saying that the mitigation lacks, however, is a performance standard, and therefore the EIR improperly defers mitigation measures for wind impacts. We have identified that there's three main problems with this conclusion. First, there are unique rules that apply to mitigation measures when an impact is determined to be significant and unavoidable and not able to be mitigated to a less than significant standard despite such mitigation. The adequacy of the city's wind mitigation measure has to be assessed against those rules and not the case law involving mitigation needed to reduce an impact to less than significant. And then third, when the wind measure is assessed against the rules for significant and unavoidable impacts, it becomes clear that the measure does actually include a performance standard that the mitigation measure aims to meet, but properly discloses that it might not. And actually, the law says that's okay. And Your Honor, for each of these points, I'm going to walk through some applicable case law and then talk about the wind mitigation measure. I do not want to take up too much of the court's time, but just bear with me. I'm gonna go through it systematically. As I mentioned, there are unique rules that apply when an impact is significant and unavoidable despite mitigation. But before I get into that case law, I think we need to talk briefly about what is meant by deferred mitigation, which is what the court determined was the problem with the city's wind mitigation measure. And the tentative ruling actually, accurately states the concept. Actually, at the very beginning, it's like in the beginning, it's on like page 13. I know you don't have page numbers, I'll find it for you, but it quotes, the tentative holds that the impermissible deferral of mitigation measures occurs when an EIR puts off analysis or orders a report without either setting standards or demonstrating how the impact can be mitigated in the manner described in the EIR. And so the rule against deferred mitigation applies to prevent a lead agency from relying upon a measure that's not sufficiently defined or maybe isn't shown to be completely effective, from using that to conclude a project has been mitigated to a less than significant level. So then the question is, so what happens when the EIR concludes an impact is significant and unavoidable? The courts have developed some rules on how, what is done with those mitigation measures. And what I want to do is point the court out to two cases, and I'm going to talk about each briefly. Both these cases are cited in our briefs, and the first one is actually cited extensively throughout the tentative ruling, and that is Sierra Club versus County of Fresno, the 2018 Supreme Court's case, 6 Cal 5th 502. And then the other case is King and Gardner Farms, County of Kern. And I'm going to start first to talk about the Sierra Club case. As mentioned, the court actually cites this case throughout its tentative ruling. We often call it the Friant Ranch case. So I apologize if I kind of go back and forth when I do that. So what in that case, the Supreme Court held there are a few key rules for mitigation measures when an impact is found to be significant and unavoidable. And the first rule is that the EIR has to disclose the impacts are significant and unavoidable, and then disclose any feasible mitigation. And that's just the typical general rule really under CEQA, that there's no dispute that a lead agency has to adopt all feasible mitigation measures regardless of what, if it's still significant and unavoidable. We still have to adopt everything that is feasible. Then what the Supreme Court says that mitigation measures for significant and unavoidable impact do not have to fully mitigate that impact. And of course, that makes sense too, that the Supreme Court holds that the inclusion of a mitigation measure that reduces an environmental impact is permitted, even if the measure won't reduce the impact to a level below the threshold of significance. And then the Supreme Court goes on to say, if the lead agency is going to say that that mitigation measure will be partially effective, it must support that with evidence. And the Supreme Court says that, that it may adopt a mitigation measure that won't reduce the impacts to below the level of significance, but it has to just demonstrate, in quote, good faith that measures will at least be partially effective. But the court holds that, in quotes, precise quantitative performance standards are not required. That's actually at page 523 of the Friant Ranch case. And rather, the conclusion that if a mitigation measure is going to be partially effective, it has to be based on evidence in the record. So those are the standards that had been set by the California Supreme Court in the Sierra Club case. And so then 2 years later, the King and Gardner Farms versus County of Kern case, which is found at 45 Cal App 5th 814, confirmed these rules and actually enumerated them and kind of stated it very succinctly that the lead agency must, one, first, find the measures are at least partially effective, two, that all feasible mitigation measures have been adopted, and three, that the mitigation impacts will not be impacted to a level that less than significant, and support all of those things with substantial evidence. But it adds a little bit more in terms of what happens when, the effectiveness of a mitigation measure is uncertain, which is our situation here, as Your Honor notes. In that case, the EIR must state that the mitigation measures are uncertain and conclude that the impact is still significant and unavoidable. And what King and Gardner Farms say is that uncertainty in the extent the measure will be effective, as well as the reasons for that uncertainty, are important facts that must be disclosed in the EIR. But you could still include these measures in the EIR because you've disclosed how effective these are. These are the rules that actually have to be applied to the wind mitigation measure here, because these are the rules that apply when an impact is significant and unavoidable, and not like the case that was cited in the tentative ruling and what was cited by petitioners, Endangered Habitat League. And the reason for this is that, as we already discussed, the rule against deferred mitigation doesn't address when the lead agency isn't relying upon the mitigation to get us down to a level less than significant. If the lead agency has concluded that the impact is significant and unavoidable and cannot be feasibly mitigated to less than significant, it's not relying on deferred mitigation to reach this conclusion. And indeed, one reason, and often a main reason sometimes, that an impact may be significant and unavoidable is that the mitigation to fully address that impact is not feasible or is uncertain. And that's actually the case here. And actually, this was like really helpfully kind of identified as why that's not deferred mitigation. In the case of California Native Plant Society versus the city of Rancho Cordova, which is at 172 Calap 4th, 603, on pages 622. This case is cited in our brief as well. What the court notes is that concerns about whether a specific mitigation measure will actually work as advertised or can actually be carried out, will be a success, or, if it's uncertain, those all go to like feasibility issues as to the mitigation measure, not, as the Native Plant Society case hold, not to whether the formulation has been improperly deferred. And I know I'm going kind of fast through these cases, Your Honor, but what I want to stress here then is that likewise, the cases on the need for a performance standard in a deferred, if you're going to have an improper or have a deferred mitigation measure and the need to put a performance standard in there are not really applicable when the standard is not required to show that mitigations can bring you down to less than significant. Such a standard is not required for mitigation, not aimed to reduce an impact to a less than significant level. The way to think about it is a performance standard is really just a form of evidence used by a lead agency to show that their findings are supported by substantial evidence, that we're going to say this measure we can say this impact will be less than significant because we can show that this measure will get us to this performance standard. It doesn't apply when there's no reduction being relied upon by the mitigation measure.
Well, let me stop you there, because I understand your argument. There's different standards. But what's not clear to me is when you say there's, some unavoidable amount of impact that's going to happen, but here's something that we can at least bring it down to a reasonable amount. Your suggestion is that you don't need any standard at all. And what concerns me here is, reading this proposal, it really doesn't tell me anything about what the city might do. We have to. They don't have to do anything. If they're satisfied, they don't have to do anything. And if they think they should do something, there's nothing that says how you measure what they should do other than here's a whole bunch of ideas out there. How am I supposed to evaluate that?
Well, respectfully, Your Honor, I don't think that's an accurate description of what the mitigation measure provides. And I would also say that, we don't have to prove that the mitigation measure will get us down to a specific performance standard, because the EIR has already disclosed that we can't do that. That's why it's significant and unavoidable. But the answer to your concern actually is really addressed when we walk through the mitigation measure. And again, I'm going to go step by step because I think it's important here, because I understand. I think that, there was a lot put out here and there's a lot of paper, but if you actually look at the terms of the mitigation measure, you'll see that there actually is a performance standard provided. There's a process for getting to that performance standard, but a disclosure in the EIR that standard may not be able to be reached. And that's what's required by the Friant Ranch case and the King of Gardner Farms case. And those are the ones as we have to look at the mitigation measure through. As I said, that it has a performance standard that the mitigation aims to meet and properly discloses that it might not. So the mitigation is found at AR 874 through 875. The very first sentence in the mitigation measure is the following: with the goal of preventing to the extent feasible a net increase in the number of hazardous wind exceedance locations compared to existing conditions. This is the performance standard. That is the quantitative objective the city is trying to meet. as understood that this is imposed at each building during the phasing of the project. The EIR disclosed that it's a phased project so that wind impacts will change over time with each new building. I want to also say that this objective, this standard is stated at the very first sentence in the MMRP at AR 486. This is also explained in the response to comments at AR 12641 through page 42, where it explains why this is a quantitative performance standard, an objective that is going to be met. So then we have to continue reading through the mitigation measure. Next, the measure explains how this is going to be carried out for each building phase. And so that, as the court has acknowledged, that the analysis in the EIR was done with, as I call it, like the block style. So it definitely, we could not analyze the exact wind impacts based on the building designs because we don't have them. So the wind analysis is going to be conducted by a qualified wind consultant at each building phase. And then they're going to perform basically the same test that was performed in the EIR, but with the buildings, with the actual building design. And depending upon where it is in the phase, some of these, when it's done, some of the buildings will have been designed. And so it will get more and more accurate during the process. So this is an expert wind consultant with city oversight, and then the report has to be provided to the city. So the first part of it says that if the wind consultant demonstrates that the design would not create a net increase in hazardous wind hours or locations as compared to existing conditions, no further review is required. Your Honor, that is saying that's the threshold of significance in the wind impact, is no net increase in wind hazards compared to then existing conditions. So the problem that the court found that this seemed like, oh, we don't have to do anything more, that's true because that's actually, it identified that there wasn't an impact. Therefore, there wouldn't be any mitigation imposed. Now, as the EIR disclosed, this maybe isn't very likely, right? Because we do identify that existing conditions are already pretty significant, and we do predict that the project will create significant and unavoidable impacts. So, but again, that is the city applying that performance standard, confirming if there's no net increase, then no mitigation is needed. The mitigation measure goes on to state that if the wind analysis determines that the building design would increase the hours of wind hazard or the number of test points above existing conditions, then mitigation measures have to be provided, which can include design changes, landscaping, installation of canopies. There's a long laundry list, as the court recognized, of different features that can be imposed to eliminate or reduce the wind hazard to the maximum extent feasible. Now, again, the city is applying the performance standard here. We're trying to get to the threshold, but it's uncertain whether or not these design changes will get us there. And the city planning department is the right agency, the right expert to determine feasibility here, because they're the expert on compatibility with city planning and building codes. And for example, they're not going to agree to a design change that would just close off an entire, public sidewalk. That might actually prevent the wind, but that would not be feasible and not appropriate. But the goal is, and what the city has committed to in this, is that we're going to get us down as much as feasibly possible to no net increase over existing conditions. I would also stress, Your Honor, that we have to remember that this is a unique city threshold. This is not a threshold found else in CEQA. This is just the city. The only other jurisdiction we're aware of that treats wind as an impact is San Francisco. So this is a unique threshold of the city. So it is appropriate for the court, as we noted, to at least provide deference to the city on how it implements its own thresholds and how its own process. And it considers that threshold as no net increase over then existing conditions. And we don't have to prove that we can meet that threshold because we've already disclosed in the EIR that it's possibly we won't. And actually, likely we won't, especially in the very beginning. Like, as I said, like as more and more is built, the wind becomes, it all changes. And so the EIR admits that the impact remains significant and unavoidable, even with this mitigation. And that's at AR 876. And that's because the evidence isn't there to show that the performance standard / threshold can be met. And the EIR explains this, that it states that it can't be stated with certainty that all wind hazards identified can be eliminated. As a result, even with the implementation of this measure, the impacts would remain significant and unavoidable for the project. And so this actually complies with the law that we just talked about within the Sierra Club case and the King and Gardner Farms case. And actually, I think it's important maybe to talk about like what happened in the Bryant Ranch case, the Sierra Club case. And in that case, the problem was that the lead agencies actually said that the mitigation measures would, quote, substantially reduce the significant and unavoidable impact, but didn't include evidence to back it up. And then the court said here, there's no facts or analysis to support the inference that the measure will get to a standard that would actually reduce the impact. And so the court found that to be really misleading to the public, that the EIR said, oh, don't worry, these measures are going to substantially help things, even if things remain significant and unavoidable. And the court says, you shouldn't do that. If you don't have proof of that, you should just disclose that to the public. And this is actually the opposite. That's the opposite of what we've done here. The EIR has disclosed that it's not known whether or not this mitigation measure will have a substantial or quantifiable reduction. And so the Bryant Ranch case stands for the conclusion that it would be misleading to the public and decision makers to say otherwise, or to promise that some standard can be met. The best we can do based on the facts that are available is to say we will do all that is feasibly possible to get us down to that performance standard threshold. So then,
I hope you don't have much more.
I don't have much more. I just want to do a few things in conclusion and then talk about kind of next steps. Because what we really asked the court here is to look again at its tentative ruling and look at those cases that I mentioned with respect to the wind mitigation measure. And as the court has acknowledged that the EIR's analysis is robust, the significant and unavoidable finding was appropriate and supported by the record, the public and decision makers are well aware of the significant and unavoidable impact associated with wind hazards, and that the mitigation may not be effective to reduce it to a less than significant standard. And the city in the mitigation measure has committed to requiring design changes at each building phase to address the impacts to the extent feasible, to bring it down to that no net increase threshold performance standard as much as possible and feasible. And so we asked the court to follow the rules in Bryant Ranch, in King and Gardner Farms, and not require the city to promise a certain performance standard that the evidence shows here cannot be met. We don't want to mislead the public. We cannot say these measures are going to do X if the evidence doesn't show it. One other thing is I have to mention is that after the court does this and it still believes that the mitigation measure needs to be more defined before it can be implemented, there is no problem with the EIR in this case. And therefore, that if there's a remedy that is needed to address this issue, the proper place would be in the MMRP, the Mitigation Monitoring and Reporting Program. I want to remind the court that the CEQA requires the court to tailor the remedy to address the specific violation, and that it mandates that the order, any writ shall be limited to the actual noncompliance. And so it'd be really an error here to order any overly expensive remedy, especially because there's nothing wrong in the EIR. Its analysis was comprehensive, the findings were proper, they're supported by substantial evidence. There's nothing needed to be changed there. The EIR that merely identifies proposed mitigation measures. These measures are not actually applied to the project until the lead agency makes a decision to adopt the proposed mitigation measures when they approve the project. And though while there has been one project approval so far, there are actually many more to come in this case. And in fact, the mitigation, there has not been a project approval yet that actually, that the mitigation measures has been imposed, actually imposed on the project applicant. These are forthcoming. And so if there's any change that needs to be made to the mitigation measure, the proper place and the best place is the MMRP. I want to remind the court what that the MMRP states that at AR 486, it explains the timing of the implementation of this mitigation measure. And as we've discussed, it's before approval of a final development permit for any building within the project site proposed to be at least 100 feet tall. So that is not something that's happening anytime soon. It's quite a ways down the line. And so that, and for that same reason, petitioners cannot show any prejudice here by this alleged noncompliance. They have the burden of showing that if the court thinks there's something that needs to be refined in this mitigation measure, that omission precluded informed decision-making and public participation. It's quite the opposite here. The EIR discloses the impacts are significant and unavoidable, and the mitigation may not reduce the impacts to less than significant level, so there can be no prejudice. So we would strongly urge the court to reconsider its tentative on this. But if it's going to consider issuing any writ, that the parties will be given an opportunity to brief that issue and of remedy before the court issues any writ, because it's really important here. And so I'm not going to belabor, I'm going to say in sum, like, we would support, adoption of the tentative ruling in full, except for this one issue. And we really encourage the court to look at this carefully and look at the cases that it does cite in its tentative that really show a different outcome.
Let me ask before I get a response. The court reporter, do you need a short break?
I do, Your Honor. I was going to ask you.
Yeah, absolutely. Okay, we'll come back at 3:30 and finish the argument. Thank you.
Thank you, Your Honor.
Okay, folks. Not to use a sports analogy, but we're in the home stretch here.
I've been waiting for that.
Yeah, I tried to resist all those buttons.
There's no home runs yet today, Your Honor.
No, it's going to be, and I don't think there's a baseball equivalent of taking something under submission, which I will do because you've given me plenty of things to look at. So we need a response to the respondents' discussion of wind. Who's going to do that?
Your Honor, Ms. Wright is going to do it, but since Ms. Lively backed into a brief discussion of remedy, when I reach my closing remarks, I'll just make a mention of that. But
Fair enough.
Thank you.
Okay.
Okay, thank you, Your Honor. Just before I start, can you hear me okay with my...
I can't hear you, yes.
Okay, perfect. Thank you very much. Okay, so my first point, and that was a lot of argument for what I think is a very straightforward issue, and I think your tentative has it right. As an initial point, I heard several cases and arguments raised here for the first time, and as the city has pointed out several times, as those arguments were not raised in their brief, I respectfully request that Your Honor not consider them. However, even if you do, I still think the tentative has it right, and those cases really are not applicable, and that is not the correct analysis. The controlling case, as the tentative notes, is the Endangered Habitat League case. It's cited in the tentative. It's 131 Cal. 4th 777. And in addition to the case, we have the CEQA guidelines, section 15126.4 A1B, which mandates that the lead agency, quoting now, adopt specific performance standards of the mitigation will achieve, end quote. So CEQA does not provide an off-ramp, or a path, or any justification for a lead agency to not provide a specific performance standard. And respectfully to Ms. Dively's point, the mitigation measure does not have a performance standard. What she is quoting is a generalized goal. That's not any type of performance standard that was disclosed to the public or that the public can count on as some level to which project impacts will be mitigated. I noticed that when she was quoting the mitigation measure, she left off what I consider to be maybe one of the most significant portions of the mitigation measure. And this is at the end, quoting as follows, starting, the project sponsor and wind consultant would work together to identify measures to eliminate or reduce wind hazards to the maximum feasible extent without unduly restricting development potential. And the portion that I was referencing is the without unduly restricting development potential. And I think what I hear the city saying is pretty close to saying that they might not adopt mitigation if it in any way restricts the ability of the building to go in a certain place or to be a certain height. They might not adopt mitigation at all. So that comes far short of any type of enforceable performance standard. Going back to the controlling case, Endangered Habitat League, in that case, the court rejected a mitigation for construction noise that required an acoustical report later in time to demonstrate noise standards satisfactory to the manager of the county's building permit division. And that same person must also be satisfied that staging areas are as far away as practical. I would say that that is equivalent to the measure we have here, although I think the measure here is even more vague. So respondents attempt to distinguish that case, at least in their papers. But I don't think there's any really viable way to get around that controlling authority, and Your Honor should apply it here. So I think Ms. Dively also mentioned that she thinks the public is fully aware of all of the wind impacts that will occur and how they will be mitigated and to what extent mitigation is feasible. But that's simply not the case, Your Honor. Looking at the wind study that was provided in the administrative record, and the citation would be at AR 2998, so this page that I was going to direct you to, through AR3001. This is the only wind study in the record. There are two versions, but this is the most current version, the most recent version. And these pages depict diagrams, photos, examples of mitigation that could be applied. However, there's absolutely no quantification, no information whatsoever of whether it would be effective, to what extent it would be effective, whether it would be applied or not. And so the public, respectfully, the public has no idea what the impacts would be mitigated to, if at all. Finally, I just have one more point, Your Honor. The city argues that they should have discretion to apply their performance standards. The only case they cited for that point is the Mission Bay Alliance case. And they cited that case at 6 Alep 5th at 192. That case didn't have anything to do with a performance standard. That case that they're citing has to do with the city being able to adopt its own threshold of significance for noise impacts, which here the city has its own threshold, as Ms. Riley pointed out, for wind that they need to enforce. So the project would, if the project would create winds that exceed 36 miles per hour for more than 1 hour during daylight hours during the year. So that's the significant threshold. What the wind study found is that under different scenarios, either under, I think it was phase 1 or full project build out, there would be over 100 hours per year where that wind exceedance would be exceeded. And the EIR discloses that this is a really significant amount of wind. It is enough to blow people over. So it's significant. It should be mitigated. And again, we have no guarantee that it would be at all. So with that, I have nothing further.
All right, I think we have come to the end of the road.
Your Honor, respectfully.
Yes. Fair enough.
Yes, sorry. Everyone else got a little rebuttal.
It's a late afternoon stretch, got a little carried away here, so please.
I will try to, I know everyone's itching to get out of their seats. I just want to point out that the endangered habitat species, habitat lead case was mentioned in a footnote in the city and the petitioner's opening brief. They went through a laundry list of problems with the mitigation and wind analysis, and performance standard was kind of tacked on at the end, mostly in a footnote. They then picked it up and went with it in reply. So the fact that they're claiming that this is like new argument, it's because it's really addressing argument and reply in the tentative ruling. And Your Honor, all the cases that I have brought to discuss today with the court are cited in our briefs, and actually, as I mentioned, the Bryant Ranch cases throughout the tentative. So these are not new cases. Exactly the case all that would apply. I just want to also point out that much of what Ms. Wright actually just attacked about the mitigation and the quality of the EIR's analysis is actually what the court upheld in its tentative. And they are not actually contesting the tentative on wind. They said they loved the tentative on wind. Therefore, their attack on anything else in the wind mitigation or the analysis is just not without merit. And we, as I said, we actually support most of the court's determination on the wind issue. The only other thing I want to add is that the idea that how the city is going to apply the performance standard threshold during the mitigation, that it will require changes to the project to the extent feasible. And she called out the problem with saying, within the development potential, that's actually consistent with the definition of feasibility. It's not required to impose mitigation to the point that you can't build the project as proposed. That's not proper mitigation. And finally, Your Honor, again, I really stress that go back, read these cases, and see how that it has to be viewed through the different lens for a significant and unavoidable. Because she is right. The EIR does not say these measures will get us there. It actually says the opposite. It says we don't have the evidence right now to show that we can meet this threshold. The city is committed to doing as much as it possibly can to get there, but that's exactly what the EIR discloses, that the evidence is not there. And that's what Fire Ranch says is okay. And I will turn it over now. I will touch base on the remedy issue at the end as well after petitioners, I guess, have a closing statement to make. Thank you.
What we're at the end, and what I'm not interested is the jury summation, but a very brief closing statement if there's any issues we've left open. So, counsel, go ahead. Starting with petitioner.
Thank you, Your Honor. I just want to make 3 points. One is the city's approach. Here we've got a lot of claims of deferred mitigation. Your Honor's ruled in our favor on wind, but so far, and not on others, but there's a lot of them. We've got a lot of later added information, and there's a big debate about whether it's caused recirculation or not. And then we also have a failure to investigate, and I want to pursue that just a little bit, because the feeling about this EIR big picture, once we rise up out of the air quality and the hazmat and everything, is a lot of do it later. We'll do it later. So what Ms. Rothgate gave you was a paradigm example, or let me give you this hypothetical, Your Honor. Let's say someone published a draft EIR and they left out altogether part of the alternatives that you have to have. No project. They just left it out. Then people commented on the draft and said, wait a minute, you left it out. What do you do at that moment in time? Do you push forward and write responses to comments and try to write your way around a gap? Or do you stop and say, you're right, I have to stop and recirculate? Translate this to the RAP issue. They write something in the EIR that provides almost no useful information and has the wrong remedy, the so-called raw. A lot of people write letters saying, what are you doing? That's not applicable to this project. Where's the underlying information on remediation? We don't care how advanced you are with the DTSC. We need this in this EIR. Here, what they needed to do was say, you're right, let's stop, get it right, because the CEQA process is where you get the public review and comment. No, they pushed through to the final EIR, acknowledged their error with regard to the RAP and that they would need a RAP and all that. And I won't go over what Ms. Rosegay explained why that matters. And then they finally gave a RAP. Okay, and you say, well, why do we have a request for judicial notice? Why is it valid? Because we're just trying to illustrate that that information underlying that RAP, which is essential to understand the hazmat risk of this project, the city should have said to the applicant, give me that information. And if the answer from the applicant is, we don't have it just yet, then you stop and wait until you have an adequate EIR. You don't push forward and try to write responses to comments and hire a lot of lawyers to justify it later. That's what they should have done, because it's needed for the public to see that information on hazmat materials and comment on it and so forth. It didn't happen. It didn't happen in other places too. So finally, or secondarily, Your Honor, I'll stop on that point. The city has to investigate and push the applicant. The city can't sit back and just say, well, no one's given us anything yet, so we don't have a duty. No, they have a duty to go find out to the extent feasible, and they could have found out here, because not too long later, here comes the full-blown RAP. Big surprise. The second point I wanted to make is, why does all this matter? Why am I making this big overall point? You know, about is the flavor of what the city has done is to defer. We'll tell you later. The wind study, we'll tell you later. Eric, would you kindly just quickly, because I know the court's tired, put up the slide of the project. Just bear with me 1 second, Your Honor. So 2 things. Here's the site. This is what it is today. We all know this. We've seen the EIR. It's a seaside, heavily contaminated site. Okay, let's move forward, please, Eric. What's it going to be? So the top picture, Your Honor, is what it is today. Now, here's my favorite thing. Look at the cranes. They're pretty big, right? So now look what it's going to look like, at least according to a visual simulation in the EIR, when they're done. The cranes look like Tinker Toys. And I'm not just trying to be funny. I'm trying to say this is a project which required the the best of EIRs with full information and not things that are, we'll see you tomorrow, we'll have a study tomorrow, we'll have a study down the road, we'll sort out wind later. So I'll stop with that right there, Your Honor. And just on the issue of relief, you could take that down, please, Eric. I'm assuming on the issue of actual relief, that's for another day, because, Your Honor, I'm hoping, based on some of the comments today, we'll have more than one deficiency in the EIR. It'll be more than just wind. Certainly there should be wind, but there'll be more, perhaps. In any event, having counsel now trying to twist your arm a bit on, oh, well, what should the relief be? And be careful, judge, and all that stuff. You know, under CEQA, you tell the city what's wrong with the EIR, and then you don't jump in and constrain their discretion or order them exactly how to do things. That's the general way. I know you know that. So I think we would be talking about relief, but only after Your Honor gets to your final decision, which I hope will have quite a number of deficiencies. Thank you for your patience, Your Honor, for putting up with us this whole day.
Respondent.
Your Honor, I don't have a prepared closing statement. I just wanted to go over a couple. I'm not going to say anything. I just want to go over a couple housekeeping things. Just as a reminder, I know it was mentioned by Mr. Kremen during rail. There are 3 separate petitions here, and so there are 3 separate judgments, and that not every petitioner made the same claims. And so I just wanted to remind the court about that, and also about ruling on the request for judicial notice, and we hope that our objections will be granted and the notice denied. I wanted to again request that if, actually it sounds like petitioners agree, that if there was a possibility the court is considering issuing a writ here, that we do get an opportunity to brief the remedy and scope of that. And then finally, did the court want a transcript? Would that assist, would that be helpful to the court to try to get an expedited transcript?
No, not at this point. And I will tell you, first of all, the decision I'm going to issue will not be the writ. I will issue a decision that will look very much like what I've issued before, although there may be changes in the ultimate outcome of some of the issues when I review everything. But I will invite the parties to submit further briefing and or draft language for proposed judgments going forward. So don't worry about that. I will explicitly rule on the request for judicial notice in the ruling also going forward. The only thing I want to say, and my intention is to get an order out next week. I'm not going to keep this under submission for a long time, partly because I'll forget everything. This is a huge record. I've been working on it. I have it clearly in mind. Your arguments on both sides have been extremely helpful. I appreciate the arguments. I also appreciate the civility and professionalism of everybody involved. It's always a pleasure. I don't mind spending a lot of time with good lawyers on a serious argument. And this is a serious argument. And I want to be very clear, as you all know, my role is a very limited role. CEQA is not a statute that allows a judge to decide what's good policy or bad policy. I don't decide whether the ballpark should be put down there or not. That's not my role at all. My role is to make sure that the informational requirements of CEQA are complied with. And then thankfully, the regulations and case law give me standards and a burden of proof and how to apply that. For many of the issues, the question is substantial evidence, and my job then is simply to see is there substantial evidence. There are some issues, and there's an argument about when this applies, where the review is broader. But even under the broader analysis, the question is not whether it's the right decision or the wrong decision. It's a question of whether CEQA has been complied with and the statutory prerequisites have been followed. So I have a limited role here. And I'm glad I have that limited role because I wouldn't want to have to decide whether to put a large project anywhere. This is obviously a huge undertaking. There's been enormous efforts made by all parties, both the proponents and the opponents of this. There's been a very large record that's been prepared. I'm also quite cognizant that this ain't the end of the road. There's more approvals and proceedings and steps. I note that that a new case has just been followed dealing with the BCDC analysis. So this ain't the end of the game here. It's going to go on for a while. So I'm quite conscious of that. I'm quite conscious of the seriousness of this case and the issues raised, and I will proceed accordingly. As I said, my goal is to get a decision out next week. I'm never going to promise that that's true, but that's where my efforts are going to go. And with that, thank you very much. Have a good weekend. Enjoy the holiday weekend now that your hard work is over. Thank you.
Thank you, Your Honor.
Thank you, Your Honor, so much.
Thank you, Your Honor.
Sounds like we're into a different area. Hey, everybody. How you doing? Is the East Oakland Stadium Alliance, folks. Hold on a second. I am checking to see momentarily if we've got an email summary here. Let's see here. I don't have it yet. So, see here. All right. Hold on a second, folks. Hold on a second. Maybe it's another recess. Let's see here. One moment, folks. Okay, everybody, I'm just checking some things here. This is a complicated day. Go back here. Go here. Complicated day.
Which is prime time for not only people commuting to and from their homes, but also in the Jack London Square area, there are restaurants, there are concentrations of constituents of concern, along with consolidation of other less affected soil elsewhere on the site, and then placing an engineered
Probably discloses that it might not. So the mitigation is found at.
And in addition to the case, we have the CEQA guidelines, section 15126.4 A1B, which requires, mandates that the lead agency, quoting now, adopt specific performance standards that the mitigation will achieve, end quote. So CEQA does not provide an on-ramp or a path or any justification for a lead agency to not provide a specific performance standard. And respectfully, to the Dively's point, the mitigation measure does not have a performance standard. What she is quoting is a generalized goal. That's not any type of performance standard that will disclose to the public or that the public can count on as some level to which project impacts will be mitigated. I noticed that when she was quoting the mitigation measure, she left off what I consider to be maybe one of the most significant portions of the mitigation measure, and this is at the end, quoting as follows, starting, the project sponsor and wind consultants would work together to identify measures to eliminate or reduce wind hazards to the maximum feasible extent without unduly restricting development potential. And the portion that I was referencing is the without unduly restricting development potential. And I think what I hear the city saying is pretty close to saying that they might.
This is a project which required the best of EIRs with full information and not things that are, we'll see it tomorrow, we'll have a study tomorrow, we'll have a study down the road, we'll sort out wind later. So I'll stop with that right there, Your Honor. And just on the issue of relief, you can take that down, please, Eric. I'm assuming on the issue of actual relief, that's for another day, because, Your Honor, I'm hoping, based on some of the comments today, we'll have more than one deficiency in the EIR. It'll be more than just wind. Certainly there should be wind, but there'll be more, perhaps. In any event, having counsel now trying to twist your arm a bit on, oh, well, what should the relief be, and be careful, judge, and all that stuff. You know, under CEQA, you tell the city what's wrong with the EIR, and then you don't jump in and constrain their discretion or order them exactly how to do things. That's the general way. I know you know that. So I think we would be talking about relief, but only after Your Honor gets to your final decision, which I hope will have quite a number of deficiencies. Thank you for your patience, Your Honor, for putting up with us this whole day.
Respondent.
Your Honor, I don't have a prepared closing statement. I just wanted to go over a couple. I'm not going to have too soon. I just want to go over a couple housekeeping things. Just as a reminder, I know it was mentioned by Mr. Kremen during rail. There are 3 separate petitions here, and so there are 3 separate judgments, and that not every petitioner made the same claims. And so I just want to remind the court about that, and also about ruling on the request for judicial notice, and we hope that our objections will be granted and the notice denied. I wanted to again request that if, actually it sounds like petitioners agree, that if there was a possibility the court is considering issuing a writ here, that we do get an opportunity to brief the remedy and scope of that. And then finally, did the court want a transcript? Would that assist, would that be helpful to the court to try to get an expedited transcript?
No, not at this point. And I will tell you, first of all, the decision I'm going to issue will not be the writ. I will issue a decision that will look very much like what I've issued before, although there may be changes in the ultimate outcome of some of the issues when I review everything. But I will invite the parties to submit further briefing and or draft language for proposed judgments going forward. So don't worry about that. I will explicitly rule on the request for judicial notice in the ruling also going forward. The only thing I want to say, and my intention is to get an order out next week. I'm not going to keep this under submission for a long time. Partly because I'll forget everything. It's a huge record. I've been working on it. I have it clearly in mind. Your arguments on both sides have been extremely helpful. I appreciate the arguments. I also appreciate the civility and professionalism of everybody involved. It's always a pleasure. I don't mind spending a lot of time with lawyers on a serious argument. And this is a serious argument. And I want to be very clear, as you all know, my role is a very limited role. CEQA is not a statute that allows a judge to decide what's good policy or.
Hold that. The judge said he was going to get an order out next week. He's not and has not and will not issue a ruling tonight. So let's continue.
Bad policy. I don't decide whether the ballpark should be put down there or not. That's not my role at all. My role is to make sure that the informational requirements of CEQA are complied with. And then thankfully, the regulations and case law give me standards and a burden of proof and how to apply that. For many of the issues, the question is substantial evidence, and my job then is simply to see is there substantial evidence. There are some issues, and there's an argument about when this applies, where the review is broader. But even under the broader analysis, the question is not whether it's the right decision or the wrong decision. It's a question of whether CEQA has been complied with and the statutory prerequisites have been followed. So I have a limited role here. And I'm glad I have that limited role because I wouldn't want to have to decide whether to put a large project anywhere. This is obviously a huge undertaking. There's been enormous efforts made by all parties, both the proponents and the opponents of this. There's been a very large record that's been prepared. I'm also quite cognizant that this ain't the end of the road. There's more approvals and proceedings and steps. I note that that a new case has just been followed dealing with the BCDC analysis. So this ain't the end of the game here. It's going to go on for a while. So I'm quite conscious of that. I'm quite conscious of the seriousness of this case and the issues raised, and I will proceed accordingly. As I said, my goal is to get a decision out next week. I'm never going to promise that that's true, but that's where my efforts are going to go. And with that, thank you very much. Have a good weekend. Enjoy the holiday weekend now that your hard work is over. Thank you.
Thank you, Honor. Thank you, Honor.
And that's that. So that's where we left it. The judge will get out the order next week. And I tried to get some follow-up comment from Mike Jacob, who's in the court there. He's part of the team, as you heard. No go. I think everybody's getting ready to go and get on to Labor Day weekend vacation, So, but that's where we are. The judge will get out with order next week. And what do I expect it to be? Let me put it this way. Whatever the judge does, an appeal will be filed. And it will go on. So there you go. Whatever the judge does, one way or the other, either one side or the other will file an appeal. And it will continue. So it's at the appeal stage is when we can really start playing wins and losses, right? Because we're not there. The bottom line is at this stage, I can tell you it's going to go to appeal, period. That I know. All right, subscribe to Zoni62, bookmark oaklandnewsnowblog.com. Please. Thank you for watching, joining us with me. That ends this broadcast.